Live from the famous Courtroom 23 at the Orange County Courthouse, the 9th Judicial Circuit Court of Florida in beautiful downtown Orlando, it's the finals of the 2014 American Mock Trial Association National Championship. I'm Jeff Thomas of Kaplan Test Prep, and joining me is Josh Leckrone, coach of the University of Cincinnati,
That's all right.
and member of the AMTA Board of Directors. Josh, good to see you.
Great to see you, Jay. Great to be here in sunny Orlando, Florida, to see the two best teams in the country battle it out for the 2014 National Championship.
It has been a tremendous weekend, hasn't it?
It has. It's been a lot of great competition. Great weather, and I'm excited to see one team go away with the Calkins Trophy this weekend.
Yeah, it's going to be a wonderful competition, I'm sure, and we're very much looking forward to seeing the outcome. So we've got a couple minutes to kill before we get the official final match underway.
We have a lot of time to kill. The teams are running a little late. We had to go on live at 5 o'clock, and so we have a decent amount of time to kill. As a matter of fact, the second team has not even arrived yet, but we will go ahead and fill some time.
We'll do our best to keep folks entertained in the next few months. So why don't you talk a few months about how you got involved with mock trial? I know you were on the board now, and it is a passion of yours. You've been involved for many years. Tell us a little bit about your backstory.
Well, I competed for 4 years, way back in 1999 through 2003 at the University of Cincinnati, my alma mater. And when I graduated, I almost immediately started coaching as soon as I started into law school. And this is actually my 12th year coaching. And a few years ago, when my mentor, my coach, Katie Pridemore, retired, she suggested that I get on the American Mock Trial Association board. And here we are all these years later. And I'm happy to be on the board. This is the absolute best organization in the country for pre-law students. And it's been a blast since day one.
So tell us a little bit about the size and the scope of AMTA. I know there are thousands of students who compete in tournaments all throughout the country over the course of the spring to eventually get us to the national championships this year in Orlando.
Absolutely. In any given year, we have approximately somewhere in the high 500s, low 600 of teams. Some schools have just one team. Some schools have 2, 3, 4, even 5 teams. When this season started, way back with the case release in mid-August, there were somewhere around 600 teams competing. Beginning in the first weekend of February, Super Bowl weekend, we have 3 steps of tournaments. We have regional tournaments. The top 7 or 8 teams from each regional tournament move on to what we call ORCs. That stands for Opening Round Championship Site. And the top 6 teams at each ORC move on to where we are here this weekend in Orlando, Florida for the 2014 National Championship Tournament. 48 teams competed here, and we're down to the top 2.
That's great. So 48 teams competed over 4 rounds of tournaments over the course of the weekend, right?
That is correct.
And so it's not exactly a head-to-head single elimination tournament. How do we whittle the field down from 48 to 2?
Well, there are 3 judges with scoring ballots in every round, and there were 2 divisions of 24 teams. And what we're about to see here, an incredible matchup of the team that won each division. And that means that they won the most ballots out of 12 on their side in their division.
Sure.
And we'll introduce them here momentarily, but they each competed in 4 rounds and earned the right to go here.
That's great. So why don't we talk a little about the teams that have made it to the finals? We've got a little bit of a, do I dare say, a David versus Goliath situation orchestrating itself here? I don't know. They're both champions.
They are. They are both champions of their divisions. On its face, on paper, it looks like a little bit of a David versus Goliath situation. The 2 teams we have competing, for those of you who are not following on Twitter and Facebook this weekend, are the University of California, Los Angeles, UCLA. And their opponent today, and this is Princeton University. And as you can see on the monitor, we have UCLA coached by longtime board member and Hall of Fame coach Gonzalo Freitas. Team captain Ian Lampert, who, if you're watching at home, is really someone to watch this weekend. Probably the most visible member of the UCLA team, and a captain or a member of the team that won the national championship 3 years ago. He was a freshman on that team. He's the only member of this team that was on that national championship team 3 years ago, and he's here to bookend his time at the University of California, Los Angeles, if you will.
That's not a bad career.
No, it is not. To speak a little bit more about UCLA, who will be going defense in today's round, UCLA has won 3 national championships, 2004, 2005, and as I just mentioned a few years ago in 2011. UCLA has, prior to this weekend, boasted 27 All-Americans. A very storied history, one of the strongest programs in the country, year in and year out. How they got here this weekend. UCLA qualified 2 teams out of regional tournaments, one out of Fresno, one out of Claremont, one at a record of 7-1, one at a record of 7-0-1. Of course, that one being a tie.
Sure.
At Orcs, UCLA competed at the Newport Beach Orc. They went 6-2 and made it out to the national championship tournament this weekend. UCLA, if you're following the BBR, how we rank teams in AMTA, UCLA is technically the 3rd ranked team in the country, which is very high. And it should be noted that UCLA, this is their 4th time in the national championship round, they've never lost.
Wow. Undefeated record in the big game.
Undefeated record in the big game. All 3 previous wins, however, came in the cornfields of Des Moines, Iowa.
Okay.
So
no home court advantage tonight.
No home court advantage for UCLA. We'll see how their particular brand of mock trial plays here in Orlando. Obviously, it's played well so far this weekend, but we're bringing in some new judges, some big-name judges who we'll talk about in a moment.
Absolutely.
With specifically this weekend, it's been a good run for the University of California, Los Angeles. They have a record of 9-2-1. What that means is they won 9 ballots, they lost 2 ballots, and they tied a ballot. Those wins came 3 wins over Rhodes, a traditional powerhouse of mock trial, an excellent win for them. And as anyone will tell you, it's difficult to win 3 ballots over any team in a round. So that's particularly impressive. They had 2 wins and a tie versus University of Florida. They had 2 wins versus Northwood University and 2 wins versus NYU. If you're counting at home, that is 3 former national championship teams that they played this weekend. And they were rewarded. Mr. Lampert may not have gone away with an All-American Attorney Award, but Kyle DeCamp, another one of UCLA's attorneys, went home with an award this weekend. And, any national championship tournament you attend, UCLA is always in the running. This is absolutely no surprise that they're here.
UCLA, a proven powerhouse, here at the Big Dance one more time, hoping to defend their crown and bring home a 4th trophy to add to the collection.
Absolutely.
But it's not going to be an easy road, I'm sure.
It is not. And as I mentioned earlier, on paper it seems like UCLA could be a favorite here.
Sure.
And certainly many of those watching at home are expecting a UCLA victory. But that's why we play the games, because their opponent today, representing the state of Midlands, is Princeton University, coached by Robert Marshall, team captain Carolyn Kitchener. Miss Kitchener won 2 All-American Attorney Awards just an hour ago at the banquet, both an attorney and a witness. So she's a double threat.
Wow.
And so she's really the who we're looking for on Princeton's team. And I say this isn't an easy road for UCLA Bruins, because Princeton has amassed quite an astounding record this season. Princeton qualified out of the Newark, Delaware regionals with a record of 7-1. They qualified out of the always very difficult Washington, D.C. Orcs with a record of 6-1-1, 6 wins and 1 loss and a tie. And as Princeton sits here today, they have a rank of 67. So that's quite different from the rank of 3 held by UCLA. Sure. But again, that's why we play the games.
That's exactly right.
As a matter of fact, Princeton didn't even compete at last year's national championship tournament. So these are a fresh group of kids for the first time ever for a Princeton team competing in the national championship final round. But I say that UCLA's task today is a tall one, because Princeton's record this weekend is frankly stunning. They have won 11 ballots, 0 losses, and 1 tie.
That's
they didn't
incredible.
lose a single ballot all weekend.
Wow.
Stunning. I mean,
Unprecedented, perhaps?
I'm not the person to ask that.
Fair
I haven't
enough.
been around long enough, but it's certainly in the past several years very unprecedented. Sure. It is so rare to win 3 ballots in a single round. To do that in 3 different rounds, and in the 4th round not even lose a ballot but tie a ballot, it's pretty amazing. And I would not bet against them if I were betting. More specifically this weekend, the the Princeton Tigers had two wins versus Chicago with a tie in the first round, 3 wins over Arizona State, 3 wins over Penn State, 3 wins over Pomona. And they find themselves here with this record of 11 wins, 0 losses, and a tie. Earlier I mentioned Miss Kitchener, who won an All-American Award as both an attorney and a witness, and Mr. Brandon Holt, who won an All-American Witness Award. So, frankly, I'm excited. These are 2 astounding teams, and I think the judges got it right this week, and I think the 2 best teams are in this courtroom ready to do battle.
I have had the great opportunity to watch some of the preliminary rounds this weekend. It's hard to say preliminary rounds of the national championship, but we have seen some stellar competitions thus far, and I cannot wait to see what happens in the courtroom today. Now, for those that are uninitiated and may not know exactly how mock trial works or about the case that we're going to see, we are seeing a case in which Princeton is playing the prosecution or representing the prosecution. We have UCLA that is representing the defense, and what is amazing to me is these students, they have to prepare both sides of the case. And when did they find out which sides they were going to be representing tonight?
Well, barely an hour ago.
Unbelievable, right?
When it is unbelievable. There's a lot of nerves that go into this.
Yeah.
This is a lot of pressure, and these students literally flipped a coin at the banquet about an hour ago and determined who was going to do which side, who was going to call which witnesses. And they got in their cars and they came over here, and in a few moments they're going to be mic'd up on national television watching, with a national audience watching them online, I should say. I don't know that we're necessarily on TV.
We may be someday. It's your one.
Maybe. That's my goal, if things go well. So they really haven't had any time to even prepare, even think about what they're about to do. They're just going to go in there, leave it all on the line. And they're all champions to an extent, but one team will walk away with the cause.
Something tells me they'll rise to the challenge just fine.
Absolutely.
So give us a little preview of the case that we're going to hear about today. I'm curious as to how the process of writing the case comes together, and give folks at home a little peek at what they have to look forward to that we'll be arguing about later on this evening.
Excellent question. This year's case is entitled State of Midlands versus Whit Bowman. Unfortunately for the viewers at home, I haven't read the case in about 6 months. So my knowledge of the case is a little behind the times. There have been several changes since the time it was written. But these cases are written by a committee. The American Mock Trial Association has a civil case committee and they have a criminal case committee. This year is obviously a criminal case. And a group of 5, 6, 7 board members sit down. Usually there's a submission from a student or an attorney or someone outside of the board who gives them an idea, and the committee sits down and writes the case. This case is no different. This year's case committee chairs were Tom Parker and Jason Butler, both from the Commonwealth of Kentucky. They have written an excellent case. The case balance has been great all year. And what I mean by that is the prosecution wins versus defense wins have been pretty even pretty much throughout the year. There has not been a huge bias for one side or the other, which is the goal of AMP to do that. And more specifically with this case, we have a lowly park employee by the name of Whit Bowman, who was arguably just minding his or her own business, got involved with the wrong person by the name of Cameron Poole. Allegedly, the two cooked up a scheme to defraud the park of some money through a wristband scheme. And it was found out. And when the proverbial crap hit the fan, Cameron Poole grabbed the money, robbed the ticket taker at the front of the park, and attempted to escape. Unfortunately for Mr. Poole, and more unfortunately for the security guard Winston Thomas that followed him, they entered what was called the Tunnel of Terror. Shenanigans ensued. Officer Winston Thomas was struck by one of the cars, and unfortunately later died of his injuries. Unfortunately, Cameron Poole escaped and is at large and was nowhere to be found, and most assuredly is sitting on a beach in Mexico somewhere. But left holding the bag, literally, is Whit Bowman. And Whit Bowman is on trial for engaging in the scheme to steal money from the park, helping Mr. Poole escape, and Whit Bowman's been charged with felony murder. And for those of you not terribly familiar with criminal law, felony murder, you can be guilty of felony murder if, in fact, someone dies in the commission of a felony. Even though you didn't intend to murder someone, if someone dies in the commission of a felony, you can be charged with felony murder. Sure. And so that's essentially the case we're hearing today. There are plenty of witnesses to be called. The teams have decided which witnesses they're going to call, which order. I'm not going to comment on those until they actually happen. But suffice it to say, you can see from the live feed, there's going to be some characters today. And the folks at home are really going to enjoy what they see.
Josh, is it any coincidence that a travesty at a theme park is at the center of a case that is being tried here in Orlando, Florida? The viewers
It is coincidence. It is coincidence. I don't know for sure that that was done with coming to Orlando in mind. Perhaps it was. I'll check on that and get back with the viewers. But Rockter World Amusement Park will never be the same. Named after one of the founders of the American Mock Trial Association, Don Rockter, also from Iowa. We've had great fun with the case.
That's
great.
Been a great case. It was a fun case to read, get to know a little bit, and watch in some of the preliminary rounds this weekend. We should mention, this is a fairly obvious point, but the case is, of course, fictitious. Names, locations, etc. Any bearing to real folks is purely coincidental in nature. Everything else about this is taken incredibly seriously, though. We are in one of the most famous courthouses in all of the state of Florida. We are arguing in one of the most famous courtrooms inside of this building. The students have studied the rules of evidence intently, and they're prepared to go to battle just as if they were in a real court of law sometime after they graduate from what is sure to be a prestigious institution across the country.
Absolutely, absolutely. And you can see from the live feed that the students are slowly getting things together. You see in front of the whiteboard current AMTA president Dr. Glenn Halva Neubauer taking in the proceedings. There in the right of your screen is Will Warahay, the Tournament Administration Committee chair. He's our eye candy this weekend. A lot of the ladies in AMTA like him. We're being told by the tab director, Jonathan Woodward, who is just off camera, that we have an approximate start time of 5:25. There's a nice close-up of Dr. Glenn Halva Neubauer, the head coach of Furman University, a stalwart in the mock trial community, and as I mentioned, current president. His tenure ends today. A new president takes over for this year's board meeting in the next 2 years, and it's been a great run under Dr. Halva Neubauer. We've grown leaps and bounds under his care.
I'm sure he's pleased with the outcome of the tournament thus far, and we look forward to a great final match. Let's talk a little bit about the process of what we're actually going to see tonight. So we've got a trial that's about 3 hours in duration, but we should break down it into a little bit more component parts and have folks understand exactly what they'll be seeing when the trial gets underway. So perhaps we can pull up the run sheet of exactly what's going to happen in the trial, and you can talk us through the procedure.
Apparently we don't have that, so we're going to keep going.
Giving away our behind-the-scenes secrets.
I've got this. I've done this a million times. So what viewers at home are going to see this weekend is essentially, first, a short pre-trial. There will be some documents tendered to the bench, introductions made, things of that nature. That'll take 5, maybe 10 minutes, just some logistical things. Sure. And then each side will give an opening statement, 5 minutes each. Pretty short, but for the purposes of what we're doing here, in real life those would be much longer, as with everything else we do. But you have to keep in mind time constraints. After that, the prosecution will call 3 witnesses. They'll have 25 minutes in which time to get all 3 witnesses' direct examinations done. Then the defense attorneys will have 25 total minutes to cross-examine those 3 witnesses. We'll take a short break, which time you and I will comment on what's going on, what we like so far. Then the defense will call 3 witnesses. They'll have 25 minutes, again, to do their direct examinations. The prosecution will have 25 minutes to cross-examine their witnesses. We'll take another break. And then we'll have closing arguments. Each side gets 9 minutes. The prosecution is permitted time to give a rebuttal if they so choose to. And that's that. What will happen after that is the ballots will be taken out of the room. They will be brought back into a side room where they'll be tallied. There are 5 judges, and we'll speak about them in a moment. But there are 5 judges. Each ballot will be tallied up, and whoever wins the most ballots, our esteemed tabulation director, Mr. Jonathan Woodward, will enter the room. He will announce who won the tournament, and that team will take home the ginormous.
I was going to say.
It's big.
It's huge.
Yeah. True story. In the late 1990s, I think Maryland actually tried to concede the national championship just so they didn't have to pay to take that thing home. Just for the sake of
not getting it back.
They didn't want to take it home.
We don't cover the transportation rates for the trophy?
No comment. No comment. It travels much like the Stanley Cup. It is, I know because I saw a picture of it next to bunk beds this weekend. It's the size of a small set of children's bunk beds when it's in its case and shipped. And we lost it like 2 years ago.
Wow.
Yeah, we found it. I think UPS lost it.
There she be in all its glory.
There she is, and right next to her is the runner-up trophy, whose name, sadly, I cannot remember at the moment, but that is the runner-up trophy.
Also some size to her. It is substantial.
Indeed, indeed. Both are substantial, one slightly larger than the other, indicating who did better in that round, of course.
Fair enough. So I believe we're getting a little bit closer to getting underway. So we'll be handing over the proceedings to a presiding judge and a team to help score the competition throughout the course of the evening.
Absolutely.
So let's talk about them.
The presiding judge this afternoon is Judge Alex Farrar. He is born in Havana, Cuba, a former lawyer and police officer, and what many of you may know, the host of the nationally syndicated court show, Judge Alex. He'll be ruling on all the objections this afternoon, and he will also have a ballot in his hands scoring.
He has done 1,345 episodes of a syndicated talk show, which is 1,344 more than us.
That is stunning.
So perhaps we can get some pointers from him at the end of the broadcast tonight.
I had a little lunch with him earlier. He gave me some tips, and I'm ready to go.
That's great.
The second judge is Dean Emeritus Bruce Jacob. Mr. Jacob is from Chicago, Illinois. He was an assistant attorney general for the state of Florida in the 1960s. Mr. Jacobs actually argued the case of Gideon versus Wainwright before the Supreme Court, which is, for those of you at home or in law school or prepared to go to law school, a landmark Supreme Court case which assured the right of every criminal defendant to representation. Stunningly impressive case. Dean Jacob, I had a lovely conversation with his wife on the walk over. They actually spent the last 40 or so years in Columbus, Ohio, where I'm, the state where I'm from, as a professor at Ohio State.
Very nice. Next we have Judge Deborah Nelson.
Judge Deborah Nelson is a circuit court judge right here in this building. She was born in Miami Beach, Florida. She is a judge of this 18th Judicial Circuit. And you can hear in the background some students are chanting. They're getting ready to go. Judge Nelson most famously presided over the state of Florida versus George Zimmerman. And that's where most people will recognize her from. She got a lot of TV time for that. Yeah. So,
very nice. Our fourth judge, Judge Jose Rodriguez.
Judge Jose Rodriguez was born in Cienfuegos, Cuba. He is a alumni of our host, University of Central Florida, and he is a judge of the 9th Judicial Circuit here in Florida, a very accomplished jurist in his own right.
And lastly, filling out our judging roster tonight is Was that the last one?
That was not the last one.
We have one more, I know, right? Correct.
That's fine.
That's okay.
Apparently there are some technical difficulties,
Sure.
But our final judge is Judge Charlie Rose.
Yes, indeed.
We don't want to forget about Judge Rose. Not the TV personality, but in fact a very distinguished director of the Center for Advocacy at Stetson University School of Law right here in Orlando, one of our other sponsors this weekend. And we're so excited to have this excellent, amazing panel who are being led into the courtroom very shortly. There's Professor Charlie Rose. As you can see, he's taught trial advocacy for the National Institute of Trial Advocacy, University of Notre Dame, and even to the United States Army.
Okay. It looks like we're just about ready to get underway, and so perhaps later on after one of the breaks we'll talk about how the scoring actually takes place and how we determine a winner. But I think we're just about ready to go into the courtroom and get the proceedings underway with pretrial motions and opening statements. So any early predictions before we cast it over?
Well, if I'm a betting man, I'm going to go with experience.
All
I'm
right.
going to go with UCLA.
Very nice. We'll hold you to that at the back end. Let's toss it over to the courtroom and get things underway.
Well, it looks like that we're going to wait a few more moments. We've got a few more minutes. We've got some time to kill. Luckily, the thing I do best is talk.
Yeah, no kidding. It's great. We can fill this time without a problem.
Absolutely.
Let's talk about the scoring of the situations. We have a few moments here. So it's really easy to think that actually we're ready to roll. So I'm getting the signal that we are ready to begin the trial.
The esteemed panel's walking in. Let's turn it over.
We'll hold that question.
Good evening, Your Honor.
And Anna Neerman.
Good evening, Your Honor.
Good evening, Your Honor. My name is Ian Gabriel Lampert. To my right is Miss Carolyn Paris-Bear.
Good evening, Your Honor.
And to her right, Kyle Gomez de Camp.
Good evening, Your Honor.
We represent our client, Miss Whitney Bowman, in today's matter.
Good evening.
State ready and defense ready to proceed?
Yes, Your Honor. Before we get started, we do have a few pretrial matters.
Go ahead.
First, we have a few documents to give to you to reference during today's trial.
Okay, if you can approach the clerk and provide with the documents, please.
Yes, Your Honor. We have a copy of the indictment, the special instructions, the Midlands Penal Code, the stipulations, the order on motions in limine, the Midlands case law, and a copy of the Midlands Rules of Evidence.
I'll make sure to read those completely before you start your case.
Thank you, Your Honor.
Any other matters from the state?
Yes. At this point, I'd like to invite the court's attention to that first document I just handed you, the indictment.
Yes, ma'am.
Now, for count 1, murder, we will argue that Winston Thomas was killed as a direct and proximate result of the defendant's actions. For count 2, robbery, we will argue that the defendant was complicit to the robbery that took place in Rockter World on August 30th. For count 3, theft by deception, we will argue that the defendant accomplished theft by lying to park employees on August 30th.
Keep in mind that robberies first and murder second, but point taken. Do you have any preliminary motions before we proceed?
Yes, Your Honor. At this point, we'd like to invoke Midlands Rule of Evidence 615, which just calls for the constructive sequestration of all witnesses, with the exception of the defendant and a party representative from the state.
Defense?
We have no objection to that, Your Honor.
Okay, the witnesses are instructed that the rule of sequestration has been invoked. They are to exit the courtroom and not discuss the case with anybody at this time until instructed otherwise or the completion of the case, and counsel are to instruct their witnesses accordingly, okay?
Yes, Your Honor.
Any other motions from the state?
Just one more thing. Would you like us to ask permission before approaching the witness, opposing counsel, and the bench?
How do you normally do it?
That's what we usually do, Your Honor.
We'll go that way.
Thank you.
Okay.
And with that, the state is ready to go.
Defense?
Just a few more matters, Your Honor. If I may invite the court's attention to the indictment concerning count 3. The grand jury has charged my client not with theft by deception merely on August 30th of 2012, but between April 30th and August 30th of 2012. If the state intends to only contend that my client acted in this theft by deception on August 30th, then I'm curious as to how they'll clarify this third count.
Your Honor, if I may respond to that?
Yes.
The indictment does not say that it must be continuous between April 30th and August 30th. August 30th is between those two dates.
I'm sorry, I missed that. The indictment reads count 3 between April 30th and August 30th, 2012 in Breckinridge County, state of Midlands. Whit Bowman committed the offense of theft by deception, and it goes on.
Yes, Your Honor.
So, and your response to the defense counsel is August 30th is between April 30th and August 30th?
Yes, Your Honor. That's the theft by deception that we're concerned with today.
You're not alleging an ongoing theft by deception over a period of time?
No, Your Honor.
Is there a reason why it wasn't indicted as just August 30th as opposed to a range of time?
I don't believe so, Your Honor.
Okay. There, you have your answer. It's August 30th.
I believe so, Your Honor.
Any other motions?
Just one more document to tender for the court's convenience. It's a notice of intent to offer character evidence. The state has already signed this notice of intent. If I may approach and tender?
Yes. The prosecution has seen the notice?
Yes, I have.
Okay. Okay. Notice of intent to offer character evidence. The defendant will offer evidence of his or her own character or trait of character. The prosecutor will offer evidence of prior crimes, wrongs, or acts under 404B, and the defense will offer opinion and/or reputation evidence of character under 608A. Everybody's in agreement?
Yes, Your Honor.
Ready to proceed?
Yes, Your Honor.
State, you may proceed with your opening statement.
Yes, Your Honor. May it please the court? Opposing counsel. Members of the jury. The defendant was standing behind the controls. On August 30th, 2012, the defendant was standing behind the controls of a ride called the Tunnel of Terror at an amusement park right here in Midlands called Rock to World. It wasn't the ride the defendant usually worked. It wasn't the ride the defendant was supposed to be working that night. In fact, it was a ride the defendant was explicitly forbidden from operating. But on August 30th, the defendant needed to be there because she had a plan. Just after 8 p.m., her accomplice, a man named Cameron Poole, came into sight. Mr. Poole was holding a knife in one hand, a bag of money in the other, and had just robbed the park's ticket booth. Mr. Poole is being chased by the park security guard, Officer Winston Thomas, and the two men were running straight towards an open door in the Tunnel of Terror ride. They ran past the defendant and into the ride, and the defendant knew exactly what she was supposed to do. Right when Mr. Poole crossed the tracks of the ride, the defendant turned the lights off. In the darkness, her accomplice managed to escape through an emergency exit in the back of the Tunnel of Terror. Officer Thomas tried to follow him, but unable to see, was struck and killed by the oncoming ride. Ladies and gentlemen of the jury, throughout the robbery and the escape, and in the moment that Officer Thomas was killed, the defendant was standing behind the controls. For her role in what happened on August 30th, the defendant is being charged with 3 crimes: theft by deception, robbery, and murder. But as representatives of the people of the state of Midlands, we can't just throw out accusations. Today, we're going to prove to you beyond a reasonable doubt that the defendant is guilty of those 3 crimes. For the charge of theft by deception, we're going to show you that the defendant and her accomplice stole more than $500 at Rock to World by lying to park employees on August 30th. For the charge of robbery, we don't have to show you that the defendant was the one holding the knife or carrying the bag of cash. We just have to show you that the defendant conspired with Mr. Poole to commit robbery. And for the charge of felony murder, all we have to do is show that Officer Winston Thomas was killed during the robbery that the defendant and Mr. Poole conspired to commit. We're going to call 3 witnesses today to prove those 3 charges. You're going to hear today from Billy Isaacs. Mr. Isaacs is a former employee at Rock to World and worked on the Tunnel of Terror on August 30th. Mr. Isaacs is going to tell you that on August 30th, the defendant insisted on taking over his ride. And when Mr. Isaacs refused, the defendant lied. The defendant told Mr. Isaacs that their boss, J.C. Longstreet, told him to take over. But you're going to hear today from J.C. Longstreet, and he's going to tell you that that simply is not true. He never told the defendant to take over the Tunnel of Terror. And Mr. Longstreet's going to tell you today that the defendant was explicitly forbidden from operating that ride. Finally, you're going to hear from Tyler Hartman. She's going to tell you exactly what happened on the ride on August 30th because she was there when Officer Thomas was killed. She's going to tell you that when the defendant turned the lights off, Mr. Poole escaped through an emergency exit at the back of the ride, the same emergency exit she heard the defendant talking about just days before the robbery. At the conclusion of today's trial, my co-counsel, Caroline Kitchener, will come before you with closing arguments. At that point, it will be clear that from the moment Mr. Poole walked into the ticket booth to the moment he escaped through the emergency exit, the defendant was standing behind the controls. Thank you.
Okay, thank you, Mr. Chow. Defense?
Yes, Your Honor. May it please the court. Something's missing from that story Mr. Chow just told you. Now today, the state's going to tell you a number of facts that we as the defense don't disagree with at all. You see, it's true. In the summer of 2012, Cameron Poole stole money from Rocker World. It's true. On the night of August 30th, he held up the ticket booth at knife point. It's true. That night, Cameron Poole got away. But something's missing. Evidence. Evidence that my client, Miss Whitney Bowman, was ever involved in Cameron Poole's crimes. Members of the jury, this is Whitney Bowman. Today, you won't hear any evidence that Miss Bowman benefited financially from Cameron Poole's actions. You won't hear any testimony that Miss Bowman was anywhere near the park's ticket booth when Cameron Poole robbed it. Today, the victim of that robbery won't take the stand and give you a first-hand account linking anything that happened to Miss Bowman. And that's why, members of the jury, today, it's important to consider everything you're going to hear. To pay attention not just to everything you will hear from the state, but to everything you won't hear. Because the state just told you that Whitney Bowman intentionally turned the lights off on Cameron Poole to help him get away. But what you'll learn is that something's missing. And you'll learn that from Miss Beckett Conroy, an amusement park owner herself, who will tell you that the Tunnel of Terror ride Mr. Chow just told you about actually used to be at her own park, Rules Rivertown, before she sold it back in 2008. She'll let you know that the reason she sold that ride in the first place is because its control panel was faulty. She'll inform you that she'd seen 2 of her own employees make the mistake of hitting the light switch on that control panel when they were trying to instead turn out the lights. The evidence will show that although Miss Bowman may have been behind the controls, members of the jury, she didn't intentionally turn the lights out to help her alleged partner in crime get away. It was just a simple mistake. But that's not the only thing that's missing. The state just told you that Whitney Bowman helped Cameron Poole get away, but you'll meet a man by the name of Mr. Lou Eccles. He works security at Rocker World, and he'll tell you about some security changes he made in the summer of 2012. He'll tell you that each and every employee knew where to find the key to the back door of the Tunnel of Terror ride, knowing that they could get out in the case of an emergency. He'll let you know that every single employee at Rocker World knew that security would be stationed out in front of the ticket booth. With that in mind, what the evidence will tell you all is that Cameron Poole knew that he couldn't escape by going out the front entrance. Cameron Poole knew where to find that key to get himself out of the back door, and only Cameron Poole had the intent to commit these crimes. But members of the jury, even more is missing. The police. Not a single officer of the law will walk through that door today and take that stand. Members of the jury, you won't hear about the investigation that went underway to place my client under arrest. In fact, you'll meet a man by the name of Jack Hunter. He'll tell you that he called the police with information about Cameron Poole's involvement in the robbery. But the police only ever questioned him about Whitney Bowman. He'll tell you that when he had nothing else to say about Miss Bowman, the police hung up on him, members of the jury. But Mr. Eccholls will corroborate this story. He'll tell you that he was interviewed by the police on the night of the robbery, and again, the police only asked questions about Miss Bowman. When he tried to tell them anything else, he was threatened with arrest. Think about what they're trying to hide from you when they don't call the police here today. Think about what's missing. Today, it's important to remember that it comes down to the state to show you a clear picture that shows that my client, Whitney Bowman, is responsible for Cameron Poole's crimes. They have to prove this to you beyond a reasonable doubt. The highest burden of proof in our legal system, and a burden of proof that the evidence just doesn't support. That's why at the end of the trial, we're going to ask you to find Miss Bowman not guilty. Because something's missing from that story Mr. Chow just told you. Proof.
Thank you, Mr. DeCamp. Let's take one moment for paperwork.
Two impassioned first opening statements there.
Yeah, pretty standard opening statements. They got their witness calls out there. They laid out the facts. Nothing earth-shattering happened. Nothing to write home about. Both were excellently well delivered. Nothing too surprising in there. Two clear-cut themes. Mr. Chow and Princeton's standing behind the controls, and Mr. DeCamp's on behalf of UCLA saying something's missing, and that what's missing is evidence, proof. And, I don't think either side won a real advantage from those opening statements. I think we're still pretty much on an even keel, and we'll see what happens with the prosecution's witnesses.
The felony murder charge recently ended just for finals competition, as I understand it.
Correct.
How much do you think that impacted the opening statements?
Greatly, because you have to change your entire case, no matter which side you're on. It's a whole new charge. 3 months ago, Winston Thomas was alive, and now he's dead. And that's a huge change. It went from a robbery to a felony murder. So these are fairly new opening statements, no doubt. But again, solid opening statements. Nothing very aggressive. Not a lot of showmanship per se, but what you would expect from two very high quality teams.
Any surprises in the selection of the witnesses?
I'll be honest, I was hoping to see the defendant. I wanted to see someone cross-examine the defendant. I think that's the highlight of any of these cases. No surprise that they're not calling her because it does provide an opportunity for an excellent cross-examination should prosecution be able to pull it off. But I'm not surprised at all. These are two teams that made it here probably on the strength of a lot of good witnesses, and they've called a lot of character witnesses. You can see just seated behind the attorneys, we've got some characters coming up. So I'm not surprised at all.
We see Judge Fair deliberating right now and filling out a score sheet. What exactly is he looking for when he's evaluating the effectiveness of an opening statement?
Several things. Substance. Number one, is what you're saying correct? Are you laying out a good theory of the case, facts? He's looking for delivery, whether you deliver it well, and frankly, other things. How you move, how your hand gestures are, things of that nature. Just overall presentation.
Judge Rodriguez, need more time? I know you're translating from Spanish to English in your head, so I want to give you,
a little banter from Judge Farrar.
State, call your first witness.
Yes, Your Honor. The state calls Tyler Hartman.
Ms. Hartman, you've been sworn.
Thank you.
You may proceed.
Thank you, Your Honor. Could you please introduce yourself to the jury?
Of course. I'm Tyler Hartman.
Ms. Hartman, what do you do for a living?
Well, right now, I just sort of take work where I can get it. I'm sort of a jack of all trades, you could say. But I used to work at Rock-to-World.
You used to work at Rock-to-World. Do you still visit the amusement park?
Well, of course. I have a bunch of mates from when I used to work there. So I've been visiting a couple times a week for the past few years.
Ms. Hartman, you're our first witness. So I want to give the jury a better understanding of some of the people and places we're going to be talking about today. What exactly is Rock-to-World?
Well, it's an amusement park. You know, it's sort of like a low-budget Magic Kingdom, but dinosaur-themed.
Were you at Rock-to-World on August 30th, 2012?
Well, I was. That day I was on the ride that hit Officer Winston Thomas. It was terrifying. I believe that's why I'm here today.
Ms. Hartman, let's take a step back. What time did you get to that ride?
It must have been about an hour before closing time, so around 8 p.m.
And what ride was that?
It's a ride called the Tunnel of Terror.
Could you tell the jury a little bit more about the Tunnel of Terror?
Of course, it's your basic indoor roller coaster. It involves a small set of cars that run along a track and all sorts of scary things pop up along the way.
Now, when you got to the Tunnel of Terror, could you see who was standing behind the controls?
I could. It was Whitney Bowman.
Do you see Miss Bowman in court today?
I do.
Could you identify her by where she's sitting and an article of clothing she's wearing?
Sure, she's sitting right over there at the end of that table. She's got brown hair and she's wearing a grey cardigan.
Your Honor, let the record reflect that Ms. Hartman has accurately identified the defendant.
Record will so reflect. You may proceed.
Now, after you saw the defendant standing behind the controls, what did you do?
Well, I got onto the ride. I was in the first car.
What happened next?
Well, as soon as I got onto the ride, I heard this loud bang.
When you heard that loud bang, could you see what the defendant was doing?
I could. She was just staring at the controls, and then our ride started.
What happened when the ride started?
Well, as we were moving, I saw two people run into the ride.
Did you recognize those two people?
I could. The first one was Cameron Poole. I knew him because he worked the ticket booth that summer.
What about the second man?
The second was Officer Winston Thomas.
Could you tell where those two men were headed?
Well, Officer Thomas was just barreling after Cameron. They were booking it toward the back of the tunnel.
What were you doing?
Well, I couldn't do anything. I was strapped onto this ride. I kept yelling, "Stop, stop."
When you were yelling stop, what was the defendant doing?
She didn't do anything, just kept staring at the controls.
What happened next?
After that, I saw Cameron cross the tracks of our ride, and then all of the lights went out.
What happened after the lights went out?
They were screaming, crying. It was terrifying. And I felt the front of my buggy hit something. I'll never forget that thud.
Miss Hartman, could you tell what that thud was?
I could. When the lights came back on, I saw Officer Thomas lying across the tracks, but he wasn't moving. It looked real bad.
Now, I want to be very clear on this point. Did the lights turn off before or after Mr. Poole crossed the tracks of the ride?
After. It was right after.
Ms. Hartman, have you ever been on a ride at Rock2World that operated with the lights off?
I have. I know from my days at working at the park that it's something called blackout mode.
Could you tell the jury what blackout mode is?
Sure. It's a maintenance feature of the ride. Basically, all of the lights go out, but the ride keeps going at full speed.
Do you know how to put a ride at Rock2World into blackout mode?
Objection, improper opinion.
Overruled. Members.
Ms. Hartman, I'll ask the question again. Do you know how to put a ride at Rock2World into blackout mode?
I do. An employee at Rock2World actually shows me how to do it.
Which employee showed you blackout mode?
It was Whitney Bowman.
Now, we've talked about the defendant and Mr. Poole. Have you ever seen the two of them spend any time together at the park?
Well, of course. Practically every time I saw Whitney that summer, she was with Kevin. The two talked all the time. I mean, they were real chummy.
Have you ever heard the defendant talking about the Tunnel of Terror?
I have.
Could you tell the jury what you heard?
I overheard Whitney tell Kevin, "Don't worry, I have a plan. There's an emergency exit door at the back of the Tunnel of Terror, but we'll have to worry about the lock."
When did you hear this conversation?
A few days before August 30th.
Thank you, Ms. Hartman. I have no further questions at this time, Your Honor.
Okay. Defense?
Yes, Your Honor.
May I proceed?
Yes.
Good evening, Ms. Hartman. My name is Carolyn Paris-Bear, and I just have a few questions for you on behalf of Miss Whitney Bowman.
All right.
I want to start by talking to you about something you told us on direct examination.
Sure.
I wrote it down to make sure I got it just right. You told us that the lights in the Tunnel of Terror went off just after Cameron Poole crossed the tracks of the ride, right?
That's correct.
Well, I want to clear up the timeline of what happened that night.
Sure.
Now, when the two people started running onto the tracks of the ride, you started yelling, didn't you?
Well, I called out to Whit that maybe we should stop the ride. We didn't.
So you called out to Miss Bowman that she should stop the ride.
That's correct.
But you also called out that she should put the ride into emergency mode.
Right. Emergency mode is what every park employee is told to do in emergency situations. It's when all the lights of the ride turn on and the ride stops. But that isn't what happened.
Well, I just want to be very clear, ma'am. It was only after that you yelled to Miss Bowman to do what every park employee should do in an emergency situation that the lights went off, right?
The lights went off after.
Well, then I want to talk about what you saw when you saw Cameron Poole running on the tracks of that ride.
All right.
Now, Cameron Poole, he wasn't holding a knife, was he?
I didn't see a knife.
You also didn't see him holding a bag of any sort?
I didn't see a bag.
You didn't see Cameron Poole gesture at Miss Bowman in any way?
I didn't see him gesture. I just saw him run through the tunnel and out of the emergency exit door.
Well, you didn't hear him yell anything to Miss Bowman, did you?
I couldn't hear him yell anything. I'm not sure if he did.
You didn't even see Cameron Poole look at Miss Bowman while he was in the Tunnel of Terror, did you?
He was looking toward the path he was running at, which was the emergency exit door.
Well, then let's talk about Miss Bowman. Now, you told us that she was in the control panel of the Tunnel of Terror when that was happening, right?
That's correct.
And you told us that you had a clear view of her while this was going on.
I could see her for parts of the ride.
Just parts?
That's correct.
So you didn't see the moment when the lights went off, right?
Well, when the lights went out, I couldn't see much. The lights were out.
So you couldn't see Miss Bowman when the lights went out?
No, I couldn't. As I said, the lights were out. It was hard to see.
So you couldn't see Miss Bowman operating the control panel when the lights went out?
I couldn't. I'm sorry if I'm not being clear. When the lights were out, it was dark. I had trouble seeing.
Well, you also told us about that emergency exit in the back of the Tunnel of Terror?
I did.
Miss Bowman, she didn't follow Cameron Poole out that exit, did she?
No, it was at the controls of the ride.
Well, after you got out of the ride, ma'am, you actually saw Miss Bowman standing off to the side, right?
That's right.
Miss Bowman wasn't running away.
No, she wasn't.
She wasn't smiling.
No, she wasn't smiling. We were all pretty scared, I think.
Miss Bowman was pretty scared?
Sustained.
Well, in fact, Miss Bowman was standing there with her hands over her face, wasn't she?
That's right.
Well, then I want to talk about something else that happened right after you got off the Tunnel of Terror ride on August 30th.
All right.
Now, you were interviewed by a detective that night, right?
I was.
And that was the detective Francis Kimball, wasn't it?
That's right. Detective Kimball.
Well, this Detective Kimball, he started asking you questions about what had happened that night, right?
He asked me all sorts of things, like what I've been telling you, what time I got to the tunnel, what happened, that sort of thing.
Well, if you don't mind, I want to clarify what exactly the detective asked you.
Well, sure.
Now, the detective asked you about what had happened on the Tunnel of Terror, right?
That's right.
He asked you about the events at Rockterworld the night of August 30th.
That's correct.
But Detective Kimball didn't ask you about Haley Floyd, did he?
No. He just asked me about what happened on the ride.
Detective Kimball never asked you anything about a knife?
No, he didn't ask me about that.
Detective Kimball never asked you anything about a bag of money?
No, he just asked me about my experience on the ride.
Well, hang on, ma'am. You say that Detective Kimball asked you about your experience on the ride.
That's correct.
But isn't it true that this Detective Kimball never once mentioned the name Cameron Poole?
He didn't mention Cameron Poole. He just asked me about what happened, who was working the ride, that sort of thing.
So he asked you about who was working the ride, ma'am?
That's correct.
But not about the man who was running through it?
He didn't ask me about that.
Thank you so much for your time, Miss Hartman. I have no further questions, Your Honor.
Thank you, Ms. Paris-Bear. State, any follow-up?
No redirect, Your Honor. Can Ms. Hartman be excused?
Yes, Ms. Hartman, you may step down. Thank you very much.
Thank you very much.
Call your next witness, State.
The state called.
Sorry. Just take a moment.
Sure.
Pretty solid witness there from Princeton, Tyler Hartman. Excellent job of the witness tying in their theme of she was behind the controls, both in the direct and the cross. I thought that was excellent. I'm not in love with her Irish accent. I think it was Irish. It kind of came and went. Her emotion was good. I like the crying. It puts a, some emotion into the case because someone is dead. I wish the accent was a little bit stronger. Paris-Bear's cross-examination was excellent. It was pretty long, considering the substance of what the witness talked about. There wasn't a whole lot to talk about. Paris-Bear's cross-examination, while excellent and was so well delivered with the hand movements and the tone of voice, but pretty long. The one real takeaway from that whole exchange was that Judge Alex Ferrer, much like on television, not letting the students respond to objections. That's really going to take some weapons away from these students who are good at objections.
It'd be interesting to see when we get to the hearsay objections in particular how that plays out, I think.
Absolutely.
Yeah.
I'm curious to find out if he's going to permit any arguments with regards to objections.
And there's some important commentary here because we are judging not just the attorney performance, but the witness performance here as well, and seeing how they get into character and embody the folks that are on trial.
Absolutely. The witnesses get scored both for their direct examination performance as well as their cross-examination performance. So they're just as important to this proceeding and to the outcome of this proceeding as are the attorneys.
100%. It is amazing to watch and to remember that these are not law students. These are not attorneys. These are undergraduate students in a court of law, showing up many experts.
Absolutely, absolutely, and of course these are the two best teams in the country this year, and they're showing it. And I think Judge Farrar is about to get the proceedings back on order.
Next witness. While we wait to resume here, we do have some running commentary going on the AMTA Twitter feed as well, and want to invite folks that are watching along to send us your thoughts. We'd love to hear what you think about the trial too. Just simply go to Twitter and use hashtag AMTANCT30. That's AMTANCT30, and we'd be able to see your comments and perhaps respond to them live on the air later on today.
Sure, we may read some of your comments, we may answer some of your questions. Feel free to tell us how you think things are going, tell us who you think's winning the round, or feel free simply to insult the commentators and the job we've done today.
Yeah.
We're ready for it. We can take anything.
Evan Gerstein right now is watching and munching in a sunny Orlando afternoon. Hope he's enjoying the beach. Perhaps one of our competitors from one of the teams.
Most likely, most likely. I think there's probably a lot of competitors here in Orlando sitting by a pool or on a beach with a cold beverage.
The state calls William Isaacs. Before we begin, may I set up a chart in the courtroom?
Have you shown the chart to the defense?
Yes.
Okay. No objection?
No objection, Your Honor. Just a point of order. When counsel uses that chart, may I reposition myself so as to better see it when she uses it?
Yes, feel free to reposition yourself.
Thank you,
Co-counsel may also do the same. Good afternoon, Mr. Isaacs. You've been sworn? Okay. You may proceed.
Yes, Your Honor. Would you please introduce yourself to the jury?
All right, my name is William Isaacs, but you can call me Billy.
What do you do for a living, Mr. Isaacs?
Well, I'm a bartender down at the local bar called the Chuggies.
Have you ever heard of an amusement park here in Midlands called Rockter World?
Oh, yes, ma'am. I used to work down at Rockter World until I got fired after Whit Bowman took over my ride.
You mentioned the defendant. How do you know Whit Bowman?
Well, we worked together down at Rockter World.
While you were working at Rockter World, what did you do?
I was a ride operator, excuse me.
What exactly does a ride operator do?
Well, it's really just as simple as it sounds. We operate on the rides, make them start and stop.
Did you operate any ride in particular?
Yes, ma'am. I had the Tunnel of Terror.
Permission to approach opposing counsel and the witness in turn with what has previously been marked as State Sworn.
You may proceed.
Would Your Honor like a copy?
It's an exhibit you're showing the witness?
Yes.
Yes, please.
All right.
Thank you.
No problem. Mr. Isaacs, could you tell us what I've just handed you?
This is a picture of the control panel at the Tunnel of Terror.
Is it a fair and accurate copy of that control panel as you remember it on August 30th of 2012?
Yes, ma'am, it is. It even has the graffiti on it, just like I remember.
We offer States 1.
Defense.
Without objection, Your Honor.
Okay, comes in as the State's Exhibit 1.
Permission to publish to the jury?
You can publish to the jury.
I'm sorry, I only have 3 copies. Oh, I'll just leave it here. Permission to show an enlarged copy of States 1?
Go right ahead.
Lastly, permission for the witness to step down to make use of States 1?
You may step down, Mr. Isaacs.
All right, you want me to come down there?
Yes, Mr. Isaacs, thank you.
All right.
That's perfect, thank you. Could you show us, using this picture, exactly how you would turn the Tunnel of Terror off and on?
All right, well, to turn the ride on, you're going to press this green button marked start and number 1. And to turn the ride off, you're going to press this red button marked number 2 and stop. Don't worry about hydraulic unit. That's not important, just the button.
What does that blue lever over there do?
Right here by Billy?
Yes, that one.
Oh, well, that's the maintenance lever. That puts the ride in what we call blackout mode.
What is blackout mode?
Well, blackout mode is when all the lights on the ride turn off, but the buggies on the ride are still moving.
Would you, as a ride operator, normally operate the Tunnel of Terror in blackout mode?
No, you don't use the maintenance lever as a ride operator.
Have you ever put the Tunnel of Terror in blackout mode, Mr. Isaacs?
Well, one time when I made a mistake.
Could you show us, using this picture, how you would use that blue lever to put the Tunnel of Terror into blackout mode?
All right, well, you're going to grab hold. Well, I'm right-handed. Let me switch sides. Okay, now you're going to grab hold of this here lever, and you see the track right here. You're just going to pull it on down, and all the lights have turned off.
Thank you, Mr. Isaacs. You can retake your seat.
All right.
Now, Mr. Isaacs, you just told us that you had used the Tunnel of Terror in blackout mode once before. When did that happen?
Well, that happened on my first day working at the park.
Was there anybody around when you put the ride into blackout mode?
A few of the employees were on the ride. Luckily, no customers.
Was the defendant one of those employees?
Yes, Miss Bowman was on the ride.
And when you initiated blackout mode, did the defendant say anything?
She did. She said how awesome it would be if we could make blackout mode a usual function on the ride.
You also mentioned that you were fired from Rock World.
That's right.
When did that happen?
Oh, that happened right after I let Whit Bowman take over my ride on August 30th.
Was that the first time that you had let the defendant operate the Tunnel of Terror on your behalf?
No, Miss Bowman had taken over from me before. This was just the first time she insisted.
When did she ask you to take over the Tunnel of Terror on August 30th?
Oh, she asked me about 3 times. I guess the first time was right before lunchtime, right before I got my hot dog.
When she asked you that first time, what did you do?
Well, I didn't need her to take over the ride. My grandchildren were fine, so I didn't need to go look after them. So I stayed at the Tunnel of Terror.
When she asked you a second time, what did you do then?
I still didn't need her help, so I stayed at the Tunnel of Terror.
after the defendant asked you a third time, what did you do, Mr. Isaacs?
I stayed at the Tunnel of Terror because I didn't need her assistance.
Mr. Isaacs, how many times that day did the defendant stop by your ride?
Well, in total, she had to come by about 7 or 8 times.
Was that normal?
No. Well, Whit and I usually talk maybe 1 or 2 times a day, you know, to check in on me, but 7 or 8 times now, we weren't that friendly.
You mentioned before, though, that the defendant did end up operating the Tunnel of Terror on August 30th.
That's right.
If you refused every time that she asked, what changed?
Well, the last time she came over to the ride, she told me that Mr. Longstreet, the boss, said that she was going to take over the tunnel.
Hearsay under Rule 805.
May I respond, Your Honor?
Go ahead.
Whit Bowman's own statements are admission by party opponent and therefore not hearsay. The statements made by Mr. Longstreet are not being used for the truth of the matter asserted, but rather to show subsequent action, exactly why Mr. Isaacs let the defendant take over the Tunnel of Terror.
Overruled. You may proceed.
I'll ask the question again.
All right.
Mr. Isaacs, what changed to allow you to let the defendant operate the Tunnel of Terror in your place?
The last time she came, she told me that Mr. Longstreet, that's the owner of the park, said that she was going to take over the Tunnel of Terror and that I could go on home and get a full day's pay.
Mr. Isaacs, I want to be very clear about this.
All right.
Did you ever hear your boss, Mr. Longstreet, say that you could leave early?
No, Whit Bowman told me.
Did you hear Mr. Longstreet say that the defendant could take over the Tunnel of Terror?
No, Whit Bowman told me.
And after the defendant said that you could leave, what did you do?
Well, I packed up my lunch tin and I was heading out the park.
Before you let the defendant operate the ride, did she say anything?
She asked me a question.
What did she ask you?
She asked me if blackout mode was still working on the Tunnel of Terror.
Thank you, Mr. Isaacs.
All
No
right.
further questions at this time, Your Honor.
Thank you,
Would
Ms. Nieremend. Defense?
Would opposing counsel like me to take down the chart?
Are you going to be using the chart?
She can leave that up, Your Honor, and we're also going to be setting up another demonstrative before the cross-examination.
You've seen his demonstrative aid?
Yes, I have.
Okay.
Thank you.
Is this visible to everyone?
Your Honor, may I also reposition myself
Yes.
when necessary? Thank you.
May I proceed?
You may proceed.
Good evening, Mr. Isaacs.
Good evening, how are you doing?
I'm doing very well, thank you. How about you?
I'm well, thank you for asking.
Sure. Now,
All right.
I've just got a couple of questions for you about August 30th of 2012.
All right.
I want to talk to you about how exactly that day started for you.
Okay.
You had a conversation with your boss, J.C. Longstreet, that morning, didn't you?
That's right.
Now, what you learned is that the back door to the Tunnel of Terror was to be locked from that point on, right?
That's what I heard.
Mr. Isaacs, you're the primary operator of the Tunnel of Terror, aren't you?
I was.
And given that, it was your responsibility to keep that door locked up, right?
I suppose you could say that.
You were given the one and only key to that back door, weren't you?
Well, they put it at the control panel at the Tunnel of Terror.
Sir, you were in the control booth for most of the day on August 30th, though, right?
That's right. Right before closing time.
While you were in the control booth with that key to the back door, you noticed that the door seemed like it was opening and closing throughout the day. Right?
That's what I saw, yes, sir.
And so you went to go relock it up, didn't you?
I did.
Well, Mr. Isaacs, isn't it true that you saw someone behind that emergency exit door on August 30th?
I did. I saw Cameron.
You saw Cameron Poole behind the emergency exit door on August 30th?
That's right.
Well, Mr. Isaacs, did you ever see Whitney Bowman behind the emergency exit door on August 30th?
No, I didn't see Whit until she came and asked me some questions.
Did you ever see Whitney Bowman and Cameron Poole interact with each other at all on August 30th, sir?
No, not on August 30th.
Did you ever see Whitney Bowman hold the key to that back door of the Tunnel of Terror ride?
Hold the key? No, I didn't see that.
Well, sir, you tell us that when you saw Cameron Poole on August 30th, he seemed angry, right?
Yes, sir.
Objection, Your Honor. Speculation to the state of mind of Cameron Poole.
Overruled.
So you tell us that on August 30th, Cameron Poole seemed angry.
That's how it looked to me.
Well, Mr. Isaacs, tell the members of the jury, on August 30th, did you ever see Whitney Bowman seem upset or angry?
Upset? No, not that I can remember. Seemed like a normal day.
Well, you mentioned to us on direct examination how she spoke to you, what was it, 7 or 8 times?
That's right.
Well, Mr. Isaacs, isn't it true that on August 30th, while she was speaking to you that much, you didn't think much of it?
Not at the time, no, sir.
So at the time, you didn't think much of it, sir?
Not at the time.
Well, Mr. Isaacs, I want to go ahead and shift gears and talk about the control panels of the Tunnel of Terror and another ride at the park called the Mind Eraser.
All right, what you want to know?
Well, you're familiar with both of them, aren't you?
Well, I worked on both of them.
And you have to know the controls of the different rides at the park when you're a ride operator, don't you?
That's right. They trained us to press the on and stop button.
You think you'd recognize a copy of the Mind Eraser's controls if I showed them to you today, sir?
Yes, you have a picture?
I do, sir. Let me grab that for you.
All right.
Your Honor, at this time, let the record reflect I'm approaching opposing counsel with what's been marked for identification purposes only as Defense A.
Okay. Record will so reflect.
I've just got a couple copies of this. Permission to approach the witness with the same?
You may approach.
Mr. Isaacs, I've just handed you Defense A, a copy
right.
of the Mind Eraser's control panel.
Counsel,
Is that
do you have
accurate?
a copy for the court?
I'm sorry?
Do you have a copy for the court?
Yes, I do, Your Honor.
May I? Thank you very much.
So have I just handed you a copy of the Mind Eraser's control panel, sir?
That's what it looks like to me.
Is it fair and accurate?
Yeah, just like I remember. This
Your
one
Honor.
got the graffiti on it, too.
Certainly, sir.
All right.
Your Honor, at this time, we would like to move Defense A into evidence.
Any objection?
No objection, Your Honor.
Okay. Comes in as defense's first exhibit.
Permission to publish a smaller copy to the members of the jury,
You may publish it.
and then make use of an enlarged version of that same picture for the witness's reference.
Proceed.
Mr. Isaacs,
Yeah.
this is the same picture I've handed you, just larger, right?
That's it.
Mr. Isaacs, you tell the members of the jury that the Mind Eraser's control panel, it has more buttons than the Tunnel of Terror's control panel, right?
Yes, it does.
And the stop button on the Mind Eraser's control panel is on the right side of the panel, isn't it?
Yes, it is. On the right side, right above the start button.
And it's on the bottom half of the control panel, isn't that true?
It's in the lower right corner.
It's in the lower right corner, sir.
Yes.
Well, let's go ahead and talk about the Tunnel of Terror's control panel, what you were talking to your attorney about a few minutes ago.
All right.
Right here in the bottom right-hand corner of the Tunnel of Terror's control panel is the blue maintenance lever, right?
That's right.
And what you told us is that when you hit that lever, the lights go out.
Yes, that's called blackout mode, so the lights have turned off, but the ride is still moving.
Well, Mr. Isaacs, you know that as a ride operator, you're not supposed to put the ride in blackout mode under normal circumstances, right?
I do know that.
And like you were telling us a few minutes ago, you made the mistake of hitting that lever one day when you weren't supposed to.
That's right, on my first day when I wasn't paying attention.
On your first day on the job, you hit this lever when you were instead trying to hit the stop button, right?
That's right, my intention was to hit the stop button, excuse me, and I wasn't paying attention, so I hit the maintenance lever.
I want to talk to you about the circumstances under which you made that mistake, sir.
All right.
When you made it, was there anyone running through your ride?
Running? No.
When you made that mistake, Mr. Isaacs, was anyone screaming at you to shut the ride down immediately?
No, they don't scream at Billy.
Well, Mr. Isaacs, when you made that mistake of yours, no one was firing a gun in your direction, right?
No.
you tell the members of the jury that it was just a simple mistake.
That's right, I wasn't paying attention.
Mr. Isaacs, you tell us that you spoke to the police about everything that happened on August 30th, wouldn't you?
I answered their questions.
Well, they asked you some questions about who was operating the Tunnel of Terror.
That's right.
That was Whitney Bowman, right?
Yeah, she took over the ride for me, so I left, so it wasn't me.
They asked you questions about who was operating the Tunnel of Terror that night, but did they ask you a single question about the man that ran through it?
The man that ran through it?
Cameron Poole, sir.
Oh, no, they didn't ask me that.
Thank you, Mr. Isaacs. I appreciate your time.
All right, you too.
Thank you, sir. I have no further questions at this point. Would opposing counsel like me to take this down?
Do you have any follow-up?
No, I don't, Your Honor.
Okay.
I can take down our charts.
Certainly, I'll take this one.
The charts, and Mr. Isaacs, you may step down, sir. Thank you very much.
All right, thank you.
Is the witness excused?
Yes, Your Honor.
All right.
And, Your Honor, before the next witness is called, permission to retrieve the document I handed the witness.
Yes. Mr. Isaacs, would you do me a favor? Grab those 2 documents on your way out.
All right, I'll get them.
Thank you. You can give them to Mr. DeCamp.
Here you go.
Thank you, Mr. Isaacs. I
I
appreciate
think
it.
one of them is yours, one belongs to the state from the prior witness.
I can grab that one. Thank you so much.
Sure.
Would you like a copy as well?
Yes. Thank you.
No problem.
Kyle seems in control there.
Yeah, another strong witness. Good character. I love the character. At this rate, though, I think that there might be 2 deaths at Rockter World Amusement Park this year. He seems to be on his last legs. I got to be honest with you. If I show up at the front of a line of a ride and that gentleman is operating it, I'm not getting on.
Fair enough.
I don't know if anyone's going to survive that ride that day. But in all seriousness, a good witness. A good direct examination, got a lot out. The cross-examination was strong. The dreaded cross-examination demonstrative. No witness wants to see a demonstrative used on them in cross-examination, and UCLA, Mr. DeCamp used it very effectively. If I'm being honest, the only thing I didn't like about Kyle DeCamp's cross-examination is the shirt and tie combo he's wearing. Doesn't match at all.
Interesting critique.
It is. I don't like it. He's an all-American attorney, though, so it's in his purview to do whatever the heck he wants.
In your coaching role, I do want to ask you a question, though, about the casting of the witnesses. I saw Billy Isaacs played earlier today by a very competent NYU team, but played Billy Isaacs as a young military veteran, as opposed to the older, more experienced gentleman that we're seeing here. How do you sort of sift out your strategy when it comes to casting witnesses for roles?
Well, you have to match the right character with the right role. And I'll be honest with you, I think Princeton, they had a great character there, but I think they miscast him because, someone that old and that feeble who could barely walk up to the bench isn't going to be operating an amusement park ride. I'm not sure he could really walk through the amusement park on a regular basis. With that said, we're in a fantasy land here. We're in the state of Midlands. It doesn't exist. And they're trying to score points. They're trying to, impress and entertain the judges. And I think they did a very good job of that. UCLA's cross was very strong, though. So we'll see what the third witness has to offer. What do we have on the Twitter feed?
Yeah, we've got a flurry of comments coming on here. A lot of viewing parties happening at campuses across the country. I think it's including your alma mater, if I'm correct.
My own students in Cincinnati are watching. They posted a picture. My lovely children, including to the very far right of their picture, a senior of mine, Bennett Moss, who's graduating and attending the University of Texas Law School in the fall. I could not be prouder of him.
That's fantastic.
And I'm excited that they're watching and hopefully listening right now.
Our character's being enjoyed. Ambulum says, watching the witnesses is the best part of this entire broadcast. Not us, I mind you. It takes guts to do a full character. Another one coming.
Everybody ready?
Yes, Your Honor.
Okay.
Before we call our next witness, can we set up a chart in the well?
Yes. Have you shown it to opposing counsel?
Yes, Your Honor.
Any objection?
If proper foundation isn't laid before showing the chart, then yes, Your Honor. But as
Okay.
to setting it up there, no objection.
Okay, so set it up facing the opposite way so that
Absolutely.
or if you'd like, if it's going to be facing the witness as the witness comes in, you may want to leave it down until the witness passes the easel, maybe against your table.
Yes, Your Honor.
There we go.
May I move to see it when it's used?
Yes. Anytime there's a chart in the way, feel free either side to relocate. Okay?
Thank you, Your
You don't
Honor.
have to ask permission anymore. Call your next witness, please, State.
The state calls Mr. J.C. Longstreet to the stand.
Good afternoon, Mr. Longstreet.
Yes.
You may proceed, State.
Good evening.
Good evening.
Please introduce yourself to the jury.
I'm Jack Longstreet.
Where do you work?
I own Rockter World Amusement Park in Breckenridge County. It's just a couple of miles down the road.
Could you tell us a little bit more about Rockter World?
Sure. When I moved to Midlands, Rockter World was pretty old. It was run down. So when I had saved up enough money, I bought the park and fixed it up. Now I'd say that Rockter World is one of Midland's premier family attractions.
Oh, Mr. Longstreet, were you at Rockter World on August 30th, 2012?
I was. I was there when everything happened.
Do you know the defendant, Whitney Bowman?
I do. Whitney worked at my park for the 2011 and 2012 park seasons.
What about a man named Cameron Poole? Do you know him?
I know Cameron, too. Cameron also worked at the park, but only during the 2012 park season.
How did Mr. Poole come to work at your park?
Whitney recommended that I hire Cameron Poole.
How did that happen?
We were talking about a possible raise for Whitney, and then Whitney started telling me about a friend of hers named Cameron Poole, and how Cameron would be a perfect fit for the ticket booth, so I hired him.
Now, after you hired Mr. Poole on the defendant's recommendation, did you ever see the two of them together?
Sure. I saw them together quite frequently, especially toward the end of August of 2012.
Now, Mr. Longstreet, you said that you were at Rockter World on August 30th. Do you remember where you were around 8 p.m. that day?
I do. I was in the main office of the park.
Did you stay in your office for the rest of the day?
No, I didn't. A couple of minutes after that, I heard a scream coming from outside, so I left the office to see what was going on.
Where did you go when you heard the scream?
I ran to our main ticket booth, the front entrance area.
What did you find when you got to the ticket booth?
When I first got there, I saw that our accountant, Miss Haley Floyd, she was the one screaming.
How was Miss Floyd acting when you found her at the ticket booth?
Well, when I got a bit closer, she collapsed to the ground. She was shaking all over, and I saw that her face was pale.
Did she say anything to you at that point?
She did. She told me that the ticket booth had just been robbed at knife point, that Cameron Poole had approached her with a knife, threatened to carve her face up, and took all of the money in the ticket booth.
Mr. Longstreet, one of the key questions that we have to answer in court today is how much money was taken from Rockter World on August 30th.
Sure.
Do you know how much money was taken from the ticket booth that day?
I don't know the exact figures for how much money we had there at that time, but I did look at the midday receipts for that day, and I also brought along a chart that I had compiled that shows about how much money we took in every day.
Before we show that chart to the jury, could you tell us exactly what it's going to show?
Sure. It's a chart of the average daily revenues for our ticket booth over the entire 2012 park season.
And how did you make the chart?
I constructed the chart from our sales records and financial records.
Is the information contained within the chart maintained in the regular course of business at Rocker World?
It is. We update the sales data at the end of each day, and every month I audit this data.
Your Honor, at this point, permission for Mr. Longstreet to show his chart to the jury?
Defense.
Without objection, we believe the foundation has been laid.
So you're moving it into evidence as the next state exhibit?
Yes, Your Honor.
Okay.
Permission for Mr. Longstreet to step down and use his chart?
Yes, you can step down, sir.
Yes, Your Honor.
This will come in as the next state exhibit.
Now, Mr. Longstreet, what are we looking at here?
This is a chart of the daily ticket booth revenues for the 5 months in the 2012 park season.
What is it showing us?
It shows us that throughout the entire season, we took in over $15,000 each day at the ticket booth. And in August in particular, we took in over $20,000 each day.
Thank you, Mr. Longstreet. You can take down your chart and retake your seat.
Sir.
Thank you. Now, Mr. Longstreet, I want to ask you a couple of questions about one particular ride at your park, the Tunnel of Terror.
Sure.
Do you remember who was supposed to be working the Tunnel of Terror on August 30th, 2012?
I do. That would be the normal ride operator for the Tunnel of Terror, Mr. Billy Isaacs.
Now, on this point, Mr. Longstreet, I want to be very clear. On August 30th, did you ever tell Whit Bowman to tell Billy Isaacs to leave the Tunnel of Terror?
No, absolutely not.
That day, did you ever give the defendant permission to operate that ride?
No, I certainly didn't. Whitney Bowman wasn't even allowed to operate the Tunnel of Terror.
Why not?
I had caught her operating the Tunnel of Terror in blackout mode earlier that summer.
What exactly happened?
It was after hours, and some of the employees were riding the Tunnel of Terror. Now, I walked into the tent, and I saw the ride was in blackout mode, and Whitney was behind the controls.
What is blackout mode?
It's a maintenance feature. The lights inside the tent turn off, and the cars keep on moving along the tracks. Now, it's a strictly maintenance-only feature, and normal park employees are forbidden from even touching the maintenance lever.
Why do you have such strict rules surrounding blackout mode?
It's a safety risk. When you're inside of the tent and blackout mode is engaged, you can't see what's going on, and there are still moving vehicles. For that reason, only trained maintenance personnel are allowed to activate it.
Thank you, Mr. Longstreet. I have no further questions at this time, Your Honor.
Thank you, Ms. Kitchener. Defense?
Cross-examination. Good evening, Mr. Longstreet.
Good evening.
My name is Ian Gabriel Lampert, and I have some questions to ask you on behalf of Miss Whitney Bowman.
Certainly.
On direct examination, you said something, and I wrote it down to make sure I got right. You said you were at Rocker World, and you were there when everything happened. Is that true?
That's correct.
But, sir, you would agree with me that you weren't actually in the ticket booth when Cameron Poole held up Miss Floyd at knife point, were you?
No, I wasn't. At that point, I was still in the main office.
So that means you didn't see Cameron Poole hold anybody up at knife point, right?
That's right.
That means you didn't see the knife that was allegedly used, right?
That's right.
You didn't see Cameron Poole take even a single cent of money yourself, did you?
No, as I said, I was in the main office at that time, not at the ticket booth.
So, sir, is that a yes, that you did not see Cameron Poole take even a single cent of money himself?
That's correct.
later on you said you ran out and you saw Haley Floyd on the ground?
I did. That was after Miss Floyd had started screaming.
At that time, you didn't see Cameron Poole anywhere, did you?
No, Miss Floyd told me that he had just robbed the ticket booth and had ran.
Sir, if I could direct you back to my question, you didn't see Cameron Poole then, is that true?
That's right.
You haven't seen Cameron Poole since, have you?
No, I haven't.
You're not sure exactly how much money, if any, Cameron Poole took, are you?
That's right. Again, I don't know the exact figures.
You have averages, don't you, that you showed us on this chart?
That's right. I have daily averages for each month as well as the midday receipts for that day.
But not exact figures, as you said, right?
No, I don't have the final receipts.
Now, sir, at no point during your conversation with Miss Floyd did she claim that it was Whitney Bowman who threatened her, right?
That's right. Again, she said that Cameron Poole had just robbed the ticket booth at Knife Point.
Whitney Bowman's name didn't come up in that conversation, did it?
No, it didn't.
Sir, let's move on and talk about a man named Detective Francis Kimball. Does that name ring a bell?
Of course.
That man is a friend of yours, right?
That's right.
Detective Francis Kimball is a former employee of yours, isn't he?
That's right. Before he joined the police academy, I employed him as a security guard for a summer.
You knew him for many years, is that true?
That's right.
Detective Francis Kimball was the man who was on the scene right after that ticket booth was allegedly robbed. Is that true?
Pardon me, you're talking about directly after the robbery?
That's correct. He was on the scene, wasn't he?
That's right. He was in the main office with me before the screaming, and then we ran out together to see what was going on.
So your friend was already there at the main office before you heard even a single scream?
That's correct. He was at the main office to discuss the day's sales and to see if we needed further investigation of some discrepancies in our records.
Your friend, Detective Francis Kimball, you're aware that he had a personal relationship with the victim in this case, Officer Winston Thomas. Is that true?
Certainly. At the time that he was working at the park, Officer Thomas was also, and still, head of security.
You're aware that that relationship between Detective Francis Kimball and Officer Winston Thomas, that relationship goes back many years. Is that true?
That's right.
Sir, isn't it a fact that Detective Francis Kimball, along with you, saw the Officer Winston Thomas's body in the Tunnel of Terror ride?
That's correct. He had arrived in the Tunnel of Terror first, after pursuing a suspect, and I arrived later, after making sure that Miss Floyd was okay.
So, sir, is that a yes, that the two of you saw Officer Thomas's body in the Tunnel of Terror?
That's right.
At that time, Detective Francis Kimball seemed to be crying to you. Is that true?
He seemed shaken. I wasn't sure if he was crying.
So he might have been crying? Is that what you'd say?
Certainly.
Sir, after that, you're aware the detective went on to conduct a series of interviews, right?
He did, yes.
The detective interviewed you, is that true?
He did. He asked me for some information about employees who he did not already have information on.
The detective asked you for Miss Whitney Bowman's address, right?
That's right, he did.
Miss Whitney Bowman's phone number, right?
He did ask me for that, yes.
He didn't ask you at that time, sir, for any information about Cameron Poole, did he?
No. As I said, he wanted information that he didn't already have about my employees.
Sir, if I could direct you back to my question, he didn't ask you a single question about Cameron Poole. Is that true?
That's right.
The fact of the matter is, sir, that as you sit there testifying, you're actually angry at Miss Bowman, aren't you?
Well, certainly. The investigation showed, or I was talking to Detective Kimball about it, that Whitney had a hand in the robbery.
So you talked to the detective who told you that, is that right?
We conversed about the investigation, that's right.
The detective is the one who told you that Whitney Bowman had a hand in this robbery.
As I said, that's right.
You never saw Whitney Bowman steal a single cent of money, did you?
No, I didn't.
Thank you, sir. I have nothing further at this time.
Thank you, Mr. Lampert. Any follow-up by the state?
No redirect, Your Honor.
Thank you.
Simply ask that my witness be excused.
You may step down.
Yes, Your Honor.
At this point, Your Honor, the state rests our case in chief and requests a brief 5-minute recess.
Okay, why don't we make it 10 minutes so that we can do some note-taking? So
Yes, Your Honor.
Court will be in recess for 10 minutes.
So we're at halftime.
We are at halftime.
Twitter wants to know, what did you think of the witnesses' tie?
I enjoyed that shirt tie combination. Much better than Mr. DeCamp's. But that's besides the point. I tell you who has a great tie on, a great suit. I know because I carried it across the street is nationally syndicated talk show host Judge Alex Ferrer.
He knows how to look great.
He looks great. I carried his suit jacket across the street. It was the most expensive thing I've ever held in my hands, I think. But he's doing a great job. He's not permitting a lot of discussion, argument on the objections.
Absolutely.
He is. He's keeping things moving along. I think he's doing an excellent job. I think the students probably wish he was letting them argue a little bit more, but, it is what it is. The third witness that Princeton put up there did what it needed to do. It wasn't a sexy witness. It wasn't a character witness. It wasn't a witness that's going to laugh, make you laugh. It's not a witness that's going to cry on the stand. He's up there to get the facts out. And frankly, that's what he did. Nothing all that enthralling. We finally saw Ian Lampert, national mock trial phenomenon. Ian Lampert, 105 pounds of just mock trial machismo.
Super consistent, clear, concise, on the money. Absolutely.
Absolutely. Not the best witness that you want to see him cross-examine. Ideally, in a perfect world, we'd see him cross-examining the defendant or something of that nature. But I'm sure his closing argument is going to be fantastic. Yeah. But on the whole, a very solid case in chief put on by the prosecution. I don't know what the judges think of it, but I think it was pretty strong.
You said that the case tends to play pretty evenly when you look at the history of how the rounds have performed. Do you feel like one side is really easier than the other? Would you prefer being the defense perhaps, or do you like the state's evidence here?
I'd always take the defense.
Yeah.
If this is my team and I'm in this situation, I'm telling them to take the defense side every time. 2 reasons. Number one, I don't have a burden. If I don't have a burden of proof, it's a lot easier to make arguments. All I'm doing is poking holes in the state's case in chief. Secondly, someone told me yesterday this is a bit of figure skating. We are scoring these students on their performances. The first side that goes, that's the baseline. The judges don't know whether the other team's going to be good or not, and I think traditionally you tend to get maybe some just very average scores. Now, if you don't do as well as the team that just went before you,
there's room to decline.
Absolutely. You're probably going to get scored lower, but I just like the opportunity going second. I would prefer to be defense. I'll be honest, we were not at the banquet. We were over here meeting with the judges, doing some judge instructions, getting ready. I don't even know who won the coin toss. I don't know who picked. Perhaps someone can come in and fill us in on that information.
We'll get it, I'm sure. So a couple of folks on Twitter are commenting about potentially some hearsay objections that were missed along the lines, particularly in the last direct examination. Did you catch anything along the way? Do you think the students are being a little timid, a little nervousness setting in for the final round in front of Judge Alex?
I think the students are picking their battles. Yeah. One thing I always tell my students is to read your judges. And I think their read on Judge Ferrer right now is that he is not a huge fan of objections, and he's going to either overrule them or sustain them right away. He gave a little bit of leeway with the hearsay objections there. Sure, there's always objections missed, though. But I think that the students are deliberately kind of holding back a little bit, and it's not a bad strategy. They're reading their judges well.
Thank you for correcting me, by the way. It is so hard to call him Judge Ferrer.
It
is known as Judge Alex. I hope he doesn't mind us taking liberty with the first name.
I don't think
he does, right? No. So let's talk a little about the scoring process. We talked a little bit about it at the beginning, and we sort of talked around it a little bit during the time. It's important for folks who may not know to understand, it really doesn't matter who actually wins the case, if it's the prosecution or the defense, as much, right?
It does not. And as a matter of fact, right now they're showing on Twitter feed, if you want to send us questions, comments on...
We'll try to get them, actually.
Yeah, the internet went down. We're not looking at your Twitter feed right now because I think the Twitter world has crashed the internet here in the Orange County Courthouse. But Yeah. The scoring is this. There are 14 scores on each side. You get 10 points for each performance. Every attorney gets a score out of 10 for an opening statement, closing argument, direct examination, cross-examination. Okay. Every witness gets a score out of 10 for the direct examination and their cross-examination. At the end of the day, those are tallied up, and you get a score out of 140. And the team who scores best on that ballot, it's possible to tie. I'm not really, I don't know what would happen. I'm sure there are procedures in the tab manual if we were to tie some of these judges, but there's a reason that there's an uneven number of judges so that,
Sure.
we can shake out. But to your original question, no, not only do we not care who actually wins the trial, we don't really even ask.
Right.
We're not going to ask these judges to say, would you find this person guilty or not? The reality of the situation is when you have 3 hours to put on a complex felony murder criminal trial, I can't imagine many judges out there that would actually find in favor of the state and convict someone.
And that's in only 3 hours, to be clear.
Correct.
And only
Correct.
3. Now, question. So there are so many real permutations of this particular case. I think we have, I'm looking at my notes correctly, there are 3 potential prosecution exclusive witnesses. There are 2 potential defense exclusive witnesses. There are 6 that can be used by either side. So every trial is naturally going to play different. Was there anything that you uniquely heard in the state's case tonight that you think has to be uniquely contended with by the defense when we see that put on momentarily?
No, I'm going to flip the question.
Okay.
There's something that I uniquely did not hear.
Interesting.
And that is that the state of Midlands did not call Officer Francis Kimball. That's a very rare move. Most teams call Officer Kimball. Officer Kimball is the one that did the investigation. Officer Kimball is the one that arrested the Whit Bowman. Officer Kimball has a lot of good facts. A very strong witness for the state of Midlands. Princeton has made the decision strategically that they're not going to call Officer Kimball. Instead, they called the 2 character witnesses in Longstreet. I don't think they did that in error. I just think it's a little unusual. It's not. I've seen a lot of these rounds this year. I actually judged a round yesterday afternoon. And it's a little unusual that they didn't call Officer Kimball. I was expecting to see that. That was the biggest surprise.
I'm merging a couple questions here, but to that point, we talk about the scoring being so important at the actual performance level and the outcome being less so. Are there times when coaches would advise their teams to sort of give up the actual legal strategy battle in favor of playing a witness part that they feel more confident in or a little bit easier to get the points across with? How often does that come into play?
Absolutely. It comes into play all the time.
Yeah.
I've had that conversation with my students so many times. Don't worry about the little substantive things that might cause you to win a case in real life, in a court of trial, in a court of law, in an actual trial. Remember that the judges are scoring you. They're scoring you on a scale of 1 to 10. And a lot of times, my mantra over the years has always been, the judges hear about 1 out of every 3 words you say. Okay? And so it's half the battle is looking the part, sounding the part, having good delivery, having good hand gestures. If you're a character, having a good costume, having a good accent, just all the accoutrements, if you will. But substance is, 50-50. It's half the battle, but you really do have to focus on, at the end of the day, the judges are scoring you on a scale of 1 to 10 based upon how they liked you.
Interesting. Another question for you. A lot of innovations happening tonight for, obviously, this is our first broadcast. We've got an early ratings information, by the way. We are a hit. We have 4 times as many viewers watching on clickorleno.com than happened on any other Sunday night, is what we've been told. Right. So that's pretty good. We got a big feed on Twitter, right? We also have a court reporter in the court for the first time. I don't know the answer to this. Are the students allowed to avail themselves of the court reporter to read back testimony during the finals round, despite the fact it's not available earlier on?
Because we've never done this, I don't know, but God, I would love that.
Wouldn't that be great?
If Ian Lampert stood up and said, I'd like to ask the court reporter to read that back
yeah.
for me. You saw the one young lady get up there with her legal pad and say, I want to make sure I get this exactly right. That's an old school move. They've been doing that in mock trial for 25 years, and that had UCLA written all over it. But wouldn't it have been great if she had stood up and said, Miss Court Reporter, read this back for me. I want you to read it back. That would have been amazing. These students, and we're seeing the court reporters right there, the crew here is fantastic.
They do a great
something,
job. Boom, right on it.
Right on
Incredible.
it. It's fantastic. Later, I'm going to have them just follow Will Warahay around the entire courtroom, perhaps to the bathroom.
You're giving the secret out that we are the only two non-professionals that happen to be doing this today.
Absolutely, absolutely. There's Jonathan Woodward, tab director, in the frame there. But yeah, because this is so new with the court reporters and the fact that the students have never used them before, there's Jonathan Woodward. Had a delicious dinner at the Ravenous Pig last night.
He can't hear you.
I know he can't. Delicious dinner with Jonathan Woodward, former President David Nelmark, President-elect Justin Bernstein, Will Werhe, and I all had a delicious dinner at the Ravenous Pig here in Orlando.
Fantastic.
Shout out to the Ravenous Pig. No, I mean, it is so new. Everything we're doing here is so new. We've got a crowd of people here watching. I think this is quite an event to see. Every time there's a break, we've got some people coming out here seeing what we're up to, and we love it. I'm having fun.
It is a blast. So we might have some rule iterations to look forward to in the coming year to figure out how the court reporter may be integrated into finals preparations.
Absolutely.
That would be fun to see. So speaking along the line of preparation while folks are flying back in, it is clear. I mean, the amount of effort and energy and just sheer work that goes into preparing to compete in this competition is unbelievable. Can you give us like the short story of when the case gets released, how long it takes the teams to prepare, sort of what the process is like just to get here?
Well, the case is released usually sometime in mid-August, and the first invitationals, the practice tournaments, take place. I mean, they're earlier and earlier every year, but I mean, at this point, like the first or second week of October, so about 5 to 6 weeks later, the students are already competing using the case. The entire fall season is utilized with invitationals. There are more invitationals in January, and then the real season. The tournaments that count begin in February with our 4 weekends of regional tournaments, followed by 3 weekends of Orcs, opening round championship sites, all leading up to this tournament. So these students have been at this for 9 months, and those of us on the American Mock Trial Association Board of Directors, we're at this all year round. Once we're done with this, the students heard earlier today that there's a new case coming out next year, 2 cases coming out next year.
Really?
If you're listening at home.
That could be some breaking news.
That is breaking news, except it got broke on Twitter already.
Fair enough.
They announced, the Civil Case Committee did announce, per my reading, that not only will there be one case throughout most of the year, but there will be a separate case released after Orcs but before the National Championship Tournament. Wow. Stunning. A first for the American Mock Trial Association.
Interesting challenges ahead for 2015.
Very much so.
By the way, where do we leave Orlando? This is the last night here, and then we're off to some other city next year, as I understand it, correct?
We are.
Do you have any pull in the decision-making process here?
I have zero pull in the decision-making process.
I find that very hard to believe.
But it's a fantastic question you ask. Where can we go from Orlando? Last year we're in Washington, D.C. This year we're in Orlando. And there it is, folks. You heard it here first. Actually, you heard it last summer from the board meeting. But myself and my staff of 5 coaches at the University of Cincinnati will be hosting the 2015 National Championship Tournament, mostly because I have mental health issues. I have no idea what on God's green earth prompted me to agree to do that. But I did, and I can't wait. We have some big things in store next week.
It's going to be a lot of fun.
Looks like Judge Ferrer is taking the bench, striding up there.
Ready to begin for the defense's case.
Let's send it back over.
Thank you. Please be seated. State has rested its case. Anything before we proceed with the defense?
No, Your Honor. Ready to call our first witness.
Defense will be presenting a case.
Yes, Your Honor.
Okay. You may proceed.
The defense calls Jack Hunter to the stand.
Sir. Mr. Hunter. Mr. Lamper, you may proceed.
Yes, Your Honor. Good evening.
Evening, sir.
Could you please introduce yourself to the members of the jury?
Sure. Good evening. My name's Jack Hunter.
Mr. Hunter, what do you do for a living?
Well, right now I'm a reporter for NASCAR. I'm a journalist by trade, and I've been doing this for many years now, and actually work down at the Midlands Voice.
How'd you get involved in this field of work?
Well, I grew up on dirt tracks. I remember watching the legends of NASCAR, like Richard Petty and Dale Earnhardt on television. One day I decided I would report on them and become a NASCAR reporter. And now, I'm living the dream.
Sir, before you started working for NASCAR, what did you do?
Well, I worked at Rock the World for a series of summers.
Let's go ahead and talk about your time working at a Rock the World amusement park. When did you work there?
Well, I worked there in 2009, 2010, 2011, and the beginning of 2012, doing a bunch of odd jobs around the place.
You say odd jobs. What do you mean?
Well, for 1 year I was a janitor, and for a couple years I was a floating ride operator at the park.
Could you tell the jury what it means to be a floating ride operator?
Well, sure. When anybody called in sick or somebody had to take a break at their post, I would fill in for them.
During your time as a floating ride operator, did you ever operate the Mind Eraser?
I did indeed, yes. I did a couple times.
What about the Tunnel of Terror? Do you know that ride?
I do indeed, yes.
Did you operate that ride?
Yes, I did, twice.
Do you think you'd recognize a picture of the controls of the Tunnel of Terror if I were to show you that in court today?
I believe I would, yes.
Your Honor, permission to approach and retrieve States 1, the picture of the Tunnel of Terror?
Approach me?
No, Your Honor. Just the jury box right there.
Go right ahead.
May I approach the witness with the same?
Yes.
Thank you.
Welcome. Mr. Hunter, do you recognize that picture?
Yeah, it's the Tunnel of Terror control panel.
Your Honor, may I show the enlargement of the Tunnel of Terror control panel? The state's already shown the jury.
You can show it.
May the witness step down and make use of it?
You may step down and approach counsel, Mr. Hunter.
Thank you, Your Honor.
You could join me right here, sir.
Okay.
Mr. Hunter, are you familiar with what number 3, that blue-looking lever, depicts?
Oh, sure. This is the maintenance lever for the ride.
Sir, in order to operate that lever, do you have to pull down?
Oh, no. You barely touch that thing and the lights would go out. I had to be cautious when I bellied up to the control panel a couple times.
Sir, if you could retake your seat.
No problem.
Mr. Hunter, let's go ahead and talk about some of the other people who worked at Rock the World.
Okay.
Are you familiar with Miss Whitney Bowman?
Oh, yeah, I am.
How do you know Whit?
Well, she joined the Rock the World family back in 2011.
Do you know which rides she usually worked at Rock the World?
Yeah, she usually worked the Mind Eraser.
Sir, are the controls for the Tunnel of Terror and the controls for the Mind Eraser the same?
Oh, no, they're like light and day.
What do you mean by that?
Well, you see, the Tunnel of Terror only has 3 themes on it. Now, the Mind Eraser has a bunch of buttons and switches on it that you have to keep track of.
Do you know what's in the bottom right-hand corner of the Mind Eraser's control panel?
Well, sure, there's the start button and the stop button.
Sir, I want to go ahead and talk about August 30th of 2012.
Okay.
Were you at Rock the World on that day?
No, I was pulling into Atlanta Motor Speedway at the time for the 500.
Why weren't you at Rock the World?
Well, unfortunately, back in April, I was let go from the park because of a little bet I made.
A bet? Sir, what do you mean by a bet?
Well, some of the folks at the park bet whether or not I could sneak into the main office, and I took it up on them. They forgot that Longstreet kept a small window open to his office.
Sir, did you sneak in through the window?
It was a tight fit, that's for sure, but I wiggled my way through there.
Well, once you got into the main office through the window, what happened?
Well, I got in there and dusted myself off. And I took a look around, and there was Miss Floyd, the park's accountant. She was none too happy. She started yelling, "What are you doing? Get out! You're fired! Get out!"
After being fired from Rock the World in April of 2012, did you speak with anyone involved in the incident of August 30th, 2012?
Yes, after I saw what happened on the TV, I gave the lead investigator, Detective Kimball, a call.
What happened when you called the lead investigator in this case?
Well, I called him and said I had information about a series of meetings between Cameron Poole, J.C. Longstreet, and Haley Floyd.
What do you mean about information concerning meetings?
Well, you see, I remember that back in April, I saw something a little suspicious.
What do you mean by suspicious?
Well, you see, Cameron Poole, J.C. Longstreet, and Haley Floyd were meeting a whole bunch of times. It started just once a week at the beginning of the month, but as the month progressed, they were meeting 3-4 times a week. And all of this, mind you, was behind closed doors. I thought it was just kind of suspicious at the time.
So when you called the lead investigator in this case, what happened?
Well, I told him that I had information about meetings between management and Cameron Poole.
Sir, what happened next?
Well, the line went dead.
After the line went dead, what did you do?
I thought that Verizon had dropped my call again, so I called him back up.
What happened when you called the detective in this case for the second time?
Well, I told him, hey, I got information about meetings between management and Cameron Poole.
What, if anything, was the lead investigator's response?
Well, he said, never mind that. What do you have on Whit? Tell me about Whit.
Did the lead investigator in this case ever hear you out about what you had to say concerning Cameron Poole?
No, it was all Whit, 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 Whit.
Did the lead investigator in this case ever ask you a single question about a single person except for Miss Whitney Bowman?
Well, no. And when I couldn't give him anything on Whit, he hung up.
Thank you for your time, Mr. Hunter. Your Honor, nothing further at this time.
Thank you, State.
Yes, Your Honor, cross-examination. Before I begin, can I take down this chart?
Yes, remove the chart if you don't need it. He can, defense counsel can put it back up if he needs it.
Thank you.
Yes, Your Honor.
Good evening, Mr. Hunter.
Evening, ma'am.
My name is Caroline Kitchener. I'm just going to ask you a couple of questions tonight.
No problem. Go right ahead.
Mr. Hunter, you started working at Rocker World in 2009, right?
That's right. I started there as a janitor.
Then you moved up to a floating ride operator, right?
That's right, in 2010.
But Mr. Hunter, you always really wanted to be a journalist, right?
That's right, ever since I was a little kid watching NASCAR, that's right.
And about a year ago, that dream came true, didn't it?
It did indeed, yes.
You started working for the newspaper, the Midlands Voice?
That's right, I got a job there and started reporting on NASCAR, traveling the circuit.
But today, Mr. Hunter, you're just an intern for The Voice, right?
Oh, that's right. I still have to get my feet wet a bit.
Now, in 2011, you brought some of your stories to the editor. You showed them to the editor, right?
That's right. I'd written a series of stories on tire deflation and shock absorption, how the teams might have been cheating by using the system.
But at that point in 2011, those editors, they didn't want to publish any of your stories, did they?
Oh, no. They thought they were too complicated for the general public, so they said, sorry, we're not going to publish them.
Well, actually, Mr. Hunter, what they said is, we're looking for something more scandalous.
Objection, Your Honor. Hearsay.
Overruled.
In fact, Mr. Hunter, they told you they were looking for something more scandalous. Isn't that right?
That's right. I guess tire deflation wasn't scandalous enough.
Now, today, you've just published one article in the Midlands Voice, right?
That's right. I just got a story published about Darlington that happened this weekend.
You'd like to publish more stories, right?
Well, sure. That's why I'm traveling the circuit, or I would until I came here today.
Well, in 2012, you actually started researching a story about Rocker World, right?
No.
Well, actually, Mr. Hunter, in 2012, you headed back to Rocker World to keep your eyes open, right?
Well, I still needed a job, yes. I needed something to pay the bills.
So that's a yes to my question, Mr. Hunter. in 2012, you headed back to Rock World to keep your eyes open. Isn't that right?
That's right. I need to work, so I got to keep my eyes open.
Now, Mr. Hunter, you said that you like to write about cars, right?
Well, NASCAR specifically, and specifically the Sprint Cup.
Okay, Mr. Hunter. But to the best of your knowledge, this trial today, it's not about cars, is it?
Not that I know of.
It's about Rock World, isn't it?
Well, that's right.
Now, Mr. Hunter, you're hoping that something comes out of this trial today, aren't you?
Well, that's right. Considering I live here in Midlands, I want to know what happened.
Thank you, Mr. Hunter. I have no further questions.
Any redirect?
No, Your Honor. May Ms. Hunter step down?
Mr. Hunter, you may step down. Thank you.
Thank you, Your Honor.
Well, a patented UCLA character witness. He takes me back to my childhood. I was a big fan of the Dukes of Hazzard, and he's straight out of that. I thought it was a solid witness. Nothing too flashy. Probably a little heavy on the NASCAR references. That's kind of a thing in mock trial these days, to call these southern hillbilly types with lots of NASCAR references. I thought he maybe went to the well a few too many times. That was sort of the big confrontation we wanted, though. We had Lampert there, we had Miss Kirchner there, and there really weren't many sparks. It was pretty standard witness. He got out what he needed to get out. If I were, nothing to see here, basically.
You can meticulously see, though, Ms. Kirchner laying the foundation for the closing argument. I can see it starting to build.
Absolutely, absolutely. They know what they're doing. She picked her moments. UCLA's crosses were much longer. They went through those affidavits, and they brought out every point they possibly could. Princeton's being a little bit more, in your own words, meticulous about what questions they ask.
Chelsea on Twitter has mentioned one thing UCLA is doing already is adding backstories to the mix. How much do you think inventing character traits adds to the story in the eyes of the judges? Is that helpful?
Yeah, I mean, it's more entertaining. It gives the judges, if you just get up there and say, oh, this is my name, and start talking about the case. Is that realistic? Does that happen in real life? No, not necessarily, but again, this is a legal play. They are trying to score points with the judges, and it's good if you just get up there with an accent or, your love of NASCAR and you don't explain how you got those things. It's a little weird, so it's a good job of laying the backstories.
Several comments on Twitter, too, about the hat. You mentioned ties. We have hats here.
I would never let one of my students wear a hat in the courtroom. Obviously, it's worked out well for them. You run the risk of offending a judge if you sit in the back of the courtroom with a hat on. Judge Ferrer has probably seen it all, and so I don't think he's too concerned about it. It's working. It's part of his costume. I myself wouldn't be really comfortable with it, but it's certainly not the first time I've ever seen it.
Hey, we love the questions and comments. Keep them coming on Twitter using hashtag AMPTANCT30.
Ready to proceed?
And it looks like you're ready for the next witness.
Yes, Your Honor. The defense calls Mr. Lou Eccles to the stand.
Okay. Mr. Eccles, you've been sworn?
Yes, Your Honor.
Okay. You may proceed, sir.
Yes, Your Honor. Good evening.
Evening, sir. How are you?
Doing well, thank you. Do you think you could introduce yourself to the members of the jury?
Sure. Good evening. I'm Louis Kennedy Eccles, but everyone around the park calls me Louie.
What park are you talking about, sir?
Rock the World Amusement Park. It's where I work.
What do you do at Rock the World Amusement Park?
Well, I'm the head of security there. I've been the head ever since 2012 on what happened to Officer Thomas.
Well, you've been head since 2012, but when were you first hired to work at Rock the World?
Well, I started out as a security guard back in 2009.
Do you think you could tell the members of the jury what your duties were when you were first hired?
Sure. I mean, it was basic security guard stuff, really. Patrolling the park, escorting out unruly customers, making sure kids kept it PG on and off the rides, making sure everyone had their own admissions bracelet.
What do you know about Rock the World's admissions policy?
Well, it's been the same ever since Ailey Floyd started working at the park back in 2010. She implemented a system where there were regular wristbands and VIP wristbands, and they would be different colors and have serial numbers on the sides.
Mr. Eccles, I want to go ahead and move forward then to how your duties as a security guard changed in 2012.
Sure.
Did they change at all that summer?
Oh, yeah. The boss, Mr. Longstreet, finally gave me the okay to make some security changes I've been wanting to make for years.
Well, what was the first of those changes that you made around the park?
Well, I installed a lock on the emergency exit door in the tunnel of tear.
Why would you have to do that?
Well, sir, employees were using the door to sneak out of shifts early and also to come in late. They were also sneaking their friends in without paying, so I had to stop that.
Well, was anyone there when you made this change?
Well, sure. The person who was running the ride at the time, Whit Bowman, was standing right next to me.
Did the two of you talk to each other?
Well, yeah, she asked me what I was doing, so I told her what I was doing.
Walk the members of the jury through what it is that you told Miss Bowman in this conversation.
Well, I told her there'd be no more leaving shifts early or coming in late, that they couldn't sneak their friends in anymore, and that if anyone wanted to go out of the tunnel of tear, they'd have to worry about that lock.
Your Honor, at this time, could I ask the court reporter to read something back onto the record?
What exactly are you going to ask the court reporter to read back?
If I could have the court reporter read something that Tyler Hartman said on her direct examination and see if Mr. Eccles can corroborate what Ms. Hartman said.
State?
No objection, Your Honor.
Since there's no objection, you can read it back.
Sir, I'm looking for what it is that Ms. Hartman said in regards to the lock to Cameron Poole in a conversation.
Do you have the ability to pull that up? Mr.
Tyler Hartman.
Hartman.
The very first witness. She had a conversation with Cameron Poole talking about a lock.
Do we have two court reporters? Just one, and an assistant. So you have two people who want to kill you right now.
Certainly.
Okay.
It's in the very first witness of the trial. It's you have to worry about the lock or something along those lines. That wasn't quite it. But if nothing else, I can just ask the witness and tell him what we heard today.
Well, we can see how that goes.
Sure.
Try that.
Mr. Eccles, what we heard in trial today from Ms. Hartman was that she told Cameron Poole that they would have to worry about the lock.
Objection.
Overruled.
Is that what you told the defendant to let everyone know?
Well, yeah, I told Whit that if anyone wanted to go out the emergency exit, they'd have to worry about the lock. It's exactly what I told her.
So was what Ms. Bowman told Cameron Poole exactly what you told her to let everyone know?
Verbatim, yeah.
Well, Mr. Eccles, after you had Ms. Bowman let everyone know that they couldn't go to work late anymore, did you have a problem with employee tardiness?
Nah, people started showing up on time.
And after you told Ms. Bowman to let employees know that they couldn't cut out of their shifts early, did you have a problem with employees leaving the park early?
No, sir, we didn't.
Well, sir, you said you implemented some changes in the summer of 2012.
Yeah.
What else did you change?
Well, the second change I made was to start standing out in front of the main ticket booth toward the last hours of the day in order to make sure that employees weren't leaving early and that kids weren't sneaking back into the park using discarded wristbands.
Mr. Eccles, say that someone was leaving or entering the park between 7 and 9 p.m. on August 29th. Would they have had to pass you by?
Yeah, they would have had to walk right past me.
Well, I want to move on then to talk about August 30th, the
Sure.
next day. Were you working?
I was, yeah.
Could you walk us through how that day started for you specifically?
Well, it started with all the employees being on time for a change, which was nice.
What else happened that morning, if anything?
Well, I saw a heated conversation between the park's owner, J.C. Longstreet, and the usual ticket taker, Cameron Poole.
What did you do upon seeing this heated conversation?
Well, I immediately went over to see if Mr. Longstreet required my assistance. But as soon as I got there, Cameron turned and stormed away. And Mr. Longstreet immediately turned to me and said that Cameron had just been fired. He hadn't taken it well. I should keep an eye out for him.
Objection? Hearsay?
Let me hear that again. Can you read that back? I'm not going all the way back, just this last question.
I immediately went over to see if Mr. Longstreet required my assistance. But as soon as I got there, Cameron turned and stormed away. And Mr. Longstreet immediately turned to me and said that Cameron had just been fired. He hadn't taken it well. I should keep an eye out for him.
May I be heard?
Yes.
This is an exemption to hearsay under Rule 8031, present sense impression. May I proffer?
How that's a present sense impression?
Yes, Your Honor.
Yes, proffer.
What we just heard, Your Honor, is that there was an event, Cameron Poole being fired, and that the declarant immediately after this event took place described that event to Mr. Echolls. That qualifies under 8031.
And what's the relevance of it?
This is relevant in that we've established that Cameron Poole hadn't taken being fired well. It's the defense's contention that Cameron Poole wasn't in cahoots with Whitney Bowman, but rather, on August 30th, he committed a crime of passion, independently because he had been fired and not taken it well.
But how does him committing a crime of passion eliminate Miss Bowman?
Because it was a spur-of-the-moment action, Your Honor. That would lessen the chance that Miss Bowman could have been involved.
I see. Okay, so the nature of the comment was that he was told by Mr. Longstreet that he had just fired Mr. Poole, and Mr. Poole had not taken it well.
Yes, Your Honor.
Your Honor, may I respond?
Yes.
There's another, the last clause in that statement is that Mr. Echolls should keep an eye on Mr. Poole. That's no longer describing the event.
If I may be heard on those grounds.
Go ahead.
As for the latter portion of that statement, that isn't being offered for the truth, but rather to go on the effect, rather to go to the effect on Mr. Echolls, the park security guard.
What was the effect on him?
As security, it's his job to keep an eye out for things, and what he'll tell you in further questioning is that he did in fact see Cameron Poole later. My next question is going to be, did you end up seeing Cameron Poole later?
Again, I'm having trouble following where that part would be relevant in this case.
Where which part, Your Honor?
The fact that he told him keep an eye out for Mr. Poole.
If counsel would like to strike that part of the question, answer rather, that's fine.
Your Honor, I do believe that statement should be stricken for the record.
Okay. All right. I will overrule it as to the first part of the statement, and I'll grant your motion to strike the second part.
Mr. Echolls, did you end up seeing Cameron Poole later that day?
Unfortunately, I did.
When?
Well, it was a little after 8 p.m. I was standing out in front of the park, like usual, when I started to feel sick, so I went to go sit down on a park bench. As soon as I sit down, I saw Cameron Poole come bursting out of the ticket booth with Officer Thomas and a person who I later found out was Detective Kimball, hot on his heels. I tried to follow them, but I was too sick to stand, let alone run.
Mr. Echolls, do you know what happened to Officer Thomas that night?
I do, yeah.
Given what happened to him, did you talk to the police?
Well, I tried to.
What do you mean you tried to talk to the police?
Well, I talked to a Detective Kimball about an hour after the robbery took place.
What did the detective ask you about?
Whit Bowman. Specifically and only Whit Bowman.
Did you have things to tell the detective that didn't involve Whit Bowman?
Well, yeah. I tried to tell him what I knew about Cameron Poole, what I'd seen earlier in the day, but she was having none of it.
Did you ever get an opportunity to tell the investigating officer those things you knew about Cameron Poole and what you had seen at the park?
Nah. I tried to walk after him after he tried to end the interview, but he turned around and threatened me with arrest if I didn't stand down. So I let it go. All we ended up talking about was Whit Bowman.
Thank you for your time today, sir.
Sure.
Your Honor, I have no further questions at this point.
Good. State?
Yes, Your Honor.
Mr. Chow?
Mr. Echolls.
Yes, sir.
I just have a few questions for you about that door in the back of the Tunnel of Terror.
Emergency exit door, sir?
That's right.
Sure.
Now, throughout the summer of 2012, you noticed a problem with that door, right?
Well, yeah, that employees were using it to sneak out and sneak their friends in.
And that was a security breach, right?
Well, yeah, also a customer breach.
So you wanted to put a lock on that door.
Yeah, of course.
And you installed that lock on August 28th, 2012.
I believe so, yeah.
So on August 28th, you went over to the Tunnel of Terror.
Yeah, of course.
And the person standing behind the controls of that ride was the defendant, right?
Yeah, Whit was running the ride at that point.
And when you saw the defendant, she asked you if she needed you to put, she asked you whether you wanted her to put the ride into maintenance mode, didn't she?
Yeah, I told her I was going to do some maintenance. She asked me if I wanted to put in maintenance mode, and I said no, just turn it off.
I just want to be clear, Mr. Echolls. Maintenance mode is a mode on the ride when the lights turn off, but the ride keeps moving.
I think so, yeah.
But you had her stop the ride, right?
Well, yeah, I'm not going to walk into the ride while it's still moving.
So the defendant pushed the red button and stopped the ride.
Yeah.
And you walked into the ride to the back of the tunnel.
Yeah, me and Whit went into the ride.
That's right. The defendant followed you all the way to the back door.
Yeah, I had to come with me.
And she asked you what you were doing.
Yeah, she asked me about the lock.
And then she stood there and watched you the entire time you were installing that lock.
For about the 30 seconds it took, yeah, she was there.
I just want to be clear. This is a padlock, right?
Yeah.
There's a key that opens the lock?
Yeah.
And there's one key.
Well, yeah, it wouldn't be much of a lock if there was more than one.
And after you installed that lock, you took the key and you gave it to the defendant, didn't you?
Yeah, I gave it to Whit. I told her to hang it up in the control booth.
You gave the defendant the key to that lock just 2 days before the robbery.
Gave it to her on August 28th, so yeah.
Thank you, Mr. Eccles.
Sure.
I have no further questions.
Defense, any redirect?
No redirect, Your Honor. At this time, may the witness step down?
Yes. Mr. Eccles, you may step down.
Thank you, Your Honor.
Thank you, sir.
So Kyle DeCamp does it.
The first mistake is listening to anything I say ever.
Yeah.
Apparently, Mr. DeCamp was in the hallway while we were commentating, and huge risk, huge swing, huge miss.
Yeah.
That was awkward. It took up a bunch of time. High risk, high reward. It did not reward. Nevertheless, it was a decent direct. I like this witness. I liked his accent. There's some Twitter hate right now about the accent. I kind of like this one. I think this is the best accent that we'd had thus far.
Most believable, perhaps.
Most believable. Yeah. There's a lot of anger over his tie, which was not straight. I also noticed that. It was a nice tie, though, so I'll give him credit. A good witness. He got out what he needed. He was believable. You're right. He looks like he's 10 years old, but he was a very believable witness. Again, we're seeing the same pattern, a fairly short cross-examination from Princeton. They're picking their points, setting up. They've really kind of minimized their case, what they're trying to prove. And late-breaking news, I'm told by former American Mock Trial Association tabulation director Christopher Lyons, per Facebook, that Princeton in fact won the toss and chose to go prosecution.
There you go.
Again, something I would have not done, but kudos to them. That's the choice they made.
We also had some clarity on the question that came up about what if all the judges tie in the
Correct.
final round. And Jonathan has let us know that Princeton would win because it won more ballots in the initial 4 rounds.
Absolutely. So if all 5 judges tie, and this is Orlando, crazier things have happened.
It's true.
The defense, or excuse me, the prosecution, Princeton, would take the ballot. Another thing we just saw, there was finally a good objection battle. Judge Farrar finally let them argue. Judge Farrar effectively using the court reporter. That's why he's on TV. He knows how to do it. He used her very effectively, showing Mr. DeCamp how it's done. so to speak.
Those are the moments we relish, letting the attorneys go head-to-head and battle it out and really see them shine.
Yeah, and it was the first time, and both made incredibly good, excellent arguments. I don't think Judge Farrar's rulings have been wrong thus far. I think he's been pretty on point with everything. He's been pretty, quick to make rulings. We just saw another picture of our esteemed judging panel, and the combatants. So they're there again. They look a little disinterested, I'm not going to lie. Judge Rose is maybe asleep with his eyes open. Judge Rose may be asleep with his eyes open. Oh, no, there's some movement. But I know they're enjoying themselves. They got to love this, seeing young folks already so good at this legal stuff.
Yeah, we do have, despite the little hiccup we had, Elisa is on Twitter is advocating for the court reporters in every tournament. That would make rounds much easier, and she's creatively used the hashtag mock trial problems to accentuate that point, but perhaps that's something you guys can consider in the off season.
Correct, and I saw Aaron Kreider pointed out big twist, the court reporter with an accent. Wouldn't that be funny if the court reporter also had an accent? Excellent comment, Aaron Kreider. I appreciated that.
Ready for your next witness?
And here we go.
Yes, Your Honor. The defense would
Final
like to
witness.
call Miss Becky Conroy to the stand.
Okay. All right, Ms. Conroy, you're under oath?
Yes, Your Honor.
Okay, you may proceed.
Good evening.
Good evening.
Would you please introduce yourself to the ladies and gentlemen of the jury?
Hello, everyone. My name is Becky Phyllis Conroy.
What do you do for a living, Miss Conroy?
Well, my real passion is actually cat breeding. I specialize in exotic short hairs, but I also have a day job. I own and operate the finest water park in all of Midlands, Ruel's Rivertown.
How long have you owned and operated Ruel's Rivertown?
Let's see, it's been about 15 years now. We opened up back in 1999.
Now, Miss Conroy, we've heard a lot about a man named Cameron Poole in today's case. Do you know him?
Oh, yes, Cameron. He's one of my former employees.
What about Miss Whitney Bowman?
Oh, Whitney. Yes, she also used to work for me. She applied to work at Ruel's a few years back, and I personally interviewed her. I remember I hired Whitney on the spot when it seemed like she liked these pictures of my cats.
From your perspective as an employer, Miss Conroy, what was Whitney Bowman like as an employee?
Oh, Whitney was an excellent employee. She was the kind of person who'd always go above and beyond the call of duty. I remember she'd always follow my rules, and she'd even check in with me before she went on break or left work for the day.
From what you could see, was Miss Bowman well acquainted with other employees at the park?
Yes, I remember the other employees really liked Whitney. She would always be willing to take over for their work shifts if they had to miss work for some reason.
And based on your observations, Miss Conroy, would you say that Miss Bowman was an honest employee?
Absolutely. One of the best examples that I can think of is one time I paid Whitney too much, but the next day she gave that money right back to me.
Well, Miss Conroy, are you familiar with another amusement park in Midlands called Rockterworld?
Oh yes, Rockterworld. I've been there many times myself. I even know the owner, Mr. Longstreet.
When would you say the most recent time you went to Rockterworld was?
Let's see, the last time was August 29th, 2012. It was the day before they had that tragic incident with their security guard.
Did you see Miss Bowman at Rock-to-World on August 29th?
Yes, actually, I saw Whitney working there that day. She was operating the Tunnel of Terror, that old piece of junk.
Why do you say that?
Well, we had that very same ride at my park, Ruel's, but it had been given us so many problems.
What do you...
Your Honor, more than probative. May I explain?
Yes.
Your Honor, for the witness to testify here in court that she found the ride so unsafe in 2008 without laying any foundation as to how the ride was changed or unchanged by 2012, when the crimes being discussed here in court today actually occurred, would unfairly prejudice the jury.
Defense?
Yes, Your Honor. We're establishing Miss Conroy's knowledge of the ride before going into her further knowledge of the ride and seeing it in 2012 and whether or not those problems had been, in her opinion, repaired.
So your objection is unfairly prejudicial as compared to its probative value?
Yes, Your Honor.
Okay. I'll overrule it on those grounds. You may continue.
Miss Conroy, you were telling us about the problems you noticed with the Tunnel of Terror when it was at your park.
Yes, I just was saying that when I had that very ride, we had many issues with it.
What kind of problems?
Well, there were two main problems with the control panel. First, it was just too small, and the second issue was the fact that it was laid out very poorly.
Well, I want to take those one at a time. What do you mean by saying that the control panel on the Tunnel of Terror was too small?
Well, that control panel, it was just tiny. I mean, the buttons were only about an inch big, and the entire width of the control panel wasn't any more than about 10 inches.
What about the second issue you mentioned? What was going on there?
Well, the layout, it was very problematic. I saw two of my most experienced ride operators nudge that maintenance lever when they were reaching for the stop button.
How many times did you see that happen?
Well, I personally saw it happen twice with two different operators, and that was within the span of a couple of months.
Miss Conroy, did you ever have the Tunnel of Terror control panel repaired to fix those problems?
Well, I looked into it, but it would have cost more than the entire ride was worth to fix that problem, because we'd have to take out the whole control panel and put a different one in.
So what'd you do with the ride?
I knew that old thing was a dud, and I thought it was too much of a liability to have at my park, so I wanted to have it hauled off to the dump.
Did you have it hauled off to the dump?
Well, that depends on your definition of a dump. The ride is at Rock-to-World now.
Why is the ride at Rock-to-World, Miss Conroy?
Well, the owner of Rock-to-World, Mr. Longstreet, he bought that ride from me.
Well, ma'am, I have to ask, why did you sell a ride that was having operational difficulties to be used at another park?
You see, that's the thing. I was under the impression that Mr. Longstreet was going to take the ride apart and just use it for the spare parts. I never would have sold him the ride if I thought he was going to let people...
Speculation as to Mr. Longstreet's intentions?
Defense?
Your Honor, I believe that this was testifying about her intentions, not Mr. Longstreet's.
I'll overrule it.
Miss Conroy, had you quite finished your answer?
Oh, not quite. I was just saying that if I had known Mr. Longstreet was going to use the ride as is, I wouldn't have sold it to him.
Well, then I'd like to turn your attention back to your visit to Rock-to-World on August 29th. Did you see the Tunnel of Terror ride at Rock-to-World on that day?
Yes, I did. I saw the Tunnel of Terror that day, and I saw the control booth.
How did you get to see the control booth?
Well, when I was at the Tunnel of Terror, I saw Whitney, who was operating the ride, walk out. She went and talked to another employee, and I just walked in.
How did you just walk into the control booth?
Well, there wasn't a door, or a gate, or a rope, so I just went in.
And when you went into the control booth, did you get a chance to look at the control panel you were just telling us about?
Oh, yes. That's why I went in. I wanted to see the control panel.
From what you saw, Miss Conroy, was the control panel you saw on August 29th of 2012 different in any way from the control panel of the Tunnel of Terror at your park?
It didn't look like it to me. It looked just the same. Even that ugly graffiti was still on there.
Did the control panel that you said was giving you operational difficulties appear to have been repaired when you saw it on August 29th of 2012 at Rockter World?
From what I...
I'm sorry. Say again.
Calls for speculation as to how the witness would know if in the 4 years when she didn't own the ride, if it had been worked on.
If it appeared the same? Was that your question?
I believe the question asked if the ride had actually been operated on her. Sorry.
Re-ask the question, please.
I asked if the ride appeared to have been repaired. Would you like me to clarify?
Well, why don't you change the wording of it, and then I won't have to sustain it.
Miss Conroy, you told us earlier that in order to repair the control panel in the Tunnel of Terror, you'd have to replace the entire thing. Did the control panel that you saw on August 29th appear to have been replaced?
No, from what I could tell, it was the same control panel that had given us all those problems at Ruel's.
Speculation.
Overruled. Deal with it on cross.
Thank you for your testimony, Miss Conroy. I have no further questions at this time.
Thank you. State, your cross?
Yes, Your Honor. Good evening, Miss Conroy.
Good evening.
As you told us earlier, on direct examination, you own your own amusement park, right?
That's right. I own a water park, Ruel's Rivertown.
And that's right here in Midlands, right?
Absolutely.
Rockter World, it's also in Midlands, isn't it?
Yes, that's right.
As you told us before, you even know its owner, Mr. Longstreet. Isn't that true?
That's right.
You would say that you and Mr. Longstreet know each other from way back, right?
Yes.
But Mr. Longstreet, he's a business competitor, isn't he?
Yes, he's one of my business competitors.
His park, it competes directly with your park, doesn't it?
Yes, but I would say it doesn't compete very well.
Now, Ms. Conroy, you talked on direct examination about the Tunnel of Terror.
Yes.
I'd like to ask a few questions about that.
Sure.
Now, you said earlier that you actually sold that ride to Rockter World, didn't you?
Yes, that's right.
You said that you sold that ride to a business competitor, right?
Yes, that's right. I sold that ride to Rockter World for cheap, so Mr. Longstreet could use it for the parts, or so I thought.
That was in 2008?
Yes, that's right.
You also told us that on August 29th of 2012, you got a chance to actually go on that ride, right?
Yes, I saw the ride at Rockter World.
But Ms. Conroy, on direct examination, you said that you wouldn't have sold the ride if you thought that Mr. Longstreet was going to continue allowing it to operate, didn't you?
Yes, when I saw the ride there, I was happy. I thought Mr. Longstreet had fixed it up, but when I saw the control panel, I knew otherwise.
On August 29th of 2012, you felt safe enough to actually go on that ride yourself, right?
Yes, at first, until I saw the control panel.
When you got off the ride, you were able to take a glance at the control panel, right?
That's right. I saw the control booth and the panel inside.
And you said on direct examination, it looked the same as when you had owned it, right?
Exactly. It looked the same size, same layout.
It looked the same as you remembered it from having owned it 4 years ago?
That's a very hard ride to forget.
Now, Miss Conroy, besides knowing that it looked the same, you don't know if there was any work that was done on that control panel, do you?
Well, based on the appraisal I got of the ride, I knew that to fix it, you'd have to take out the control panel, and when I saw that the control panel was the same, I knew it hadn't been fixed.
But Miss Conroy, you can't say for sure if Mr. Longstreet had taken any measures to fix the internal workings of that control panel, can you?
No, I don't know if he did anything with the internal components.
Miss Conroy, you also talked about a problem that you were noticing with the ride and the use of blackout mode when you owned it, right?
Yes, our ride operators would nudge that blackout or maintenance lever when they were reaching for the stop button, and it would go off.
And just to be clear, you only saw that happen at your park 2 times?
Yes, that's right. 2 times, 2 different operators within the span of 7 or 8 weeks.
But Miss Conroy, when you visited the control booth and you saw the control panel on August 29th of 2012, you didn't reach down and pull that blue lever, did you?
Of course not. That would have been dangerous.
So, Miss Conroy, you don't know if the resistance of that lever has changed since you own it, do you?
No, I don't know.
Miss Conroy, you train your employees at Rules Rivertown, right?
Yes, of course.
You trained the employees who were accidentally hitting that blue lever?
Yes, I trained my employees very thoroughly, and when I saw that they kept having that issue, I knew it was an issue with the ride.
But you don't know how Rock-der-World trains its employees, do you?
No, I
don't. You don't know how Rock-der-World trains the employees who operate the Tunnel of Terror, right?
No, it's not my park.
You can't tell us at all how the training of the employees at Rules Rivertown compares to the training of the employees at Rock-der-World, right?
No, I've never been to a Rock-der-World training session.
Thank you, Ms. Conroy. I have no further questions at this time.
Okay, defense, any follow-up?
A very brief redirect, Your Honor.
Are we having a moment here or something?
I'm checking the time, sir.
Okay. I thought you were looking at me, waiting for instructions.
Ms. Conroy, how could you specifically tell that the control panel at the Tunnel of Terror hadn't been switched out?
Well, there are a couple of things. If the panel had been switched out for a new one, it wouldn't have had that same graffiti on the surface that was there when I had it. And also another clue was if you look at the screws in the corners, they were stripped, which means they don't have that little cross in it. If the control panel had been taken out, the screws would have been replaced. They wouldn't have been stripped anymore.
Thank you, ma'am. No further questions.
Okay, thank you. Anything else, State?
Brief recross, Your Honor. Ms. Conroy, you just said that when you looked at the control panel, that you were able to tell that the screws were stripped down and that the graffiti was exactly the same, right?
Oh, wait. There might have been a couple of additions of the graffiti, but I did recognize much of the graffiti that was already there.
But when you were getting off the ride and actually looking at the control panel, you only really glanced at it, right?
Yes, I glanced in at the control panel when I went into the booth.
Thank you, Ms. Conroy. No further questions.
Thank you. Nothing else?
No, Your Honor. May Ms. Conroy be excused?
Yes, Ms. Conrad, you may step down. Thank you very much.
Thank you.
Well, the case in chief for both sides are officially over. We're going to take a break here for a few moments before the closing arguments. Of course, the commentators aren't taking a break. We're going to stay live with you folks on the live feed. The last witness, Beckett Buttons Conroy, doing her best impression of my mother, the crazy cat lady, complete with the cat-themed purse in the frame the whole time. A brilliant move on her part. But I have to wonder, are the judges on character witness overload right now?
You know, that's exactly what Maggie pointed out on Twitter, too. She said UCLA went for 3 dramatic characters. Are they taking away from each other? Are they becoming a little bit hard to differentiate because of it?
Yeah. The judges have been given a clear...
Does anybody need a break before we go into closings?
We're ready to proceed, Your Honor.
Okay. State's ready as well?
Yes, Your Honor.
Okay. State, you may proceed.
May it please the court, opposing counsel, ladies and gentlemen of the jury. Just before 8 o'clock on August 30th, 2012, the defendant was standing behind the controls of the Tunnel of Terror. Now, she stood there waiting anxiously for any hint, any indication that the plan was being put into motion. Now, she didn't have to wait long. Screams, footsteps pounding against the pavement, clutching a knife in one hand and a bag of cash in the other. Mr. Poole sprinted directly toward the defendant, heading right for the employee exit at the back of the Tunnel of Terror ride. It was Miss Bowman's job to make sure that he got there. And so, at exactly the right moment, as Mr. Poole and Officer Thomas were running into the ride, Miss Bowman pulled a blue lever. A lever that every Rocker World employee knows never to touch. A lever that plunges the entire ride into darkness. The defendant pulled that lever. Cameron Poole got away, and Winston Thomas was killed. Ladies and gentlemen, the question that we have asked ourselves today is who was behind the controls? Who made it possible for Mr. Poole to escape? After all of the testimony that we have heard in this court today, the answer is clear. It was the defendant. When the defendant and Mr. Poole stole over $500 from Rocker World by creating a false impression, they committed theft by deception. And when they used force for that theft, they committed robbery. And because Winston Thomas was killed as a direct and proximate result of the defendant's actions, the defendant is guilty of felony murder. I want to talk about each of those charges in turn today. First, theft by deception. Now, in Midlands, theft by deception means stealing by creating a false impression, by lying. Miss Bowman, she lied to Mr. Isaacs when she said the boss gave him permission to go home early. And Mr. Longstreet, he never said Mr. Isaacs could leave the ride, and he never said Miss Bowman could operate the Tunnel of Terror. That was all a lie told so that the defendant could be standing behind the controls at exactly the right moment. Now, the use of force to commit theft, well, that's called robbery. Now, Cameron Poole threatened Haley Floyd with a knife so that he could steal all of the money from the Rock to World ticket booth. Now, Miss Bowman, she helped Mr. Poole escape with that money, making her complicit to robbery. Now, we're not saying the defendant was the one who held the knife or the one who ran through Rock to World with all the money. But ladies and gentlemen, she was the one who made it possible. In Midlands, that's called complicity. Complicity means that if you help someone to commit a crime, you are guilty of that same crime. So, how do we know that Miss Bowman helped Mr. Poole escape with that money? Well, Ms. Hartman told us today that just a few days before the robbery, she heard Miss Bowman say to Mr. Poole, "Don't worry. I have a plan. There's a door at the back of the Tunnel of Terror." Mr. Isaacs took the stand today and told us that on August 30th, Miss Bowman asked to take over the Tunnel of Terror 3 times. He also told us that she had never once insisted on operating that ride before. But on August 30th, the defendant knew the plan and she knew where she needed to be. Right after Mr. Poole crossed the tracks of the Tunnel of Terror, she pulled the blackout mode lever, and the ride went completely dark. Now, the defense, they tried to tell you that was a mistake, but it wasn't. It was murder. Now, we've shown you today that Winston Thomas was killed as a direct and proximate result of the defendant's actions. Now, no one disputes the fact that Officer Thomas died as a direct result of what happened in the Tunnel of Terror on August 30th, which leaves proximate cause that Officer Thomas's death was foreseeable. Well, we heard from multiple Rock to World employees today that blackout mode, it's dangerous. Everybody knows it. The cars in the ride keep moving, but all of the lights are shut off. Now, the defendant, make no mistake, ladies and gentlemen, she knew exactly what that lever did. Mr. Longstreet took the stand today and told us that he'd found Miss Bowman operating blackout mode on the Tunnel of Terror before. And when he did, he told her she could never operate that ride again. As Mr. Poole sprinted into the Tunnel of Terror, the defendant was standing behind the controls. She stood, she watched, she waited. She didn't run away because she didn't think she was going to get caught. Well, the defendant, she didn't know that Ms. Hartman had overheard her conversation with Mr. Poole about the back door of the Tunnel of Terror. She didn't know that her friend Billy Isaacs would take the stand today and tell us just how many times she asked to take over the Tunnel of Terror on August 30th. She thought she would be safe standing behind the controls. She was wrong. Find her guilty. Thank you.
Thank you, Ms. Kitchener. Defense?
Yes, Your Honor. something's missing from the story you just heard. We didn't hear anything about any scientific evidence linking Miss Bowman to this crime, any financial evidence linking Miss Bowman to Cameron Poole's crime, any forensic evidence linking my client to Cameron Poole's choices. But if there's one thing that wasn't missing from the state's argument just now, it was this word: defendant. Members of the jury, you notice how many times the prosecutors chose to call my client defendant? Say it was the defendant standing behind the controls. Do you know why they do that, members of the jury? It's no lawyer's trick. Because defendants wait in the shadows. Defendants sound like schemers and plotters. Defendants make plans. But people make mistakes. The more you think of Miss Bowman as just the defendant waiting behind the controls, the less you think of her as a person. Members of the jury, this is Whitney Bowman, a young lady who was in the wrong place at the wrong time, a young woman who made a mistake and is now being charged with murder. We learned today that Miss Bowman was an honest, hard-working, caring young woman. A woman who was happy to help out her friends at both amusement parks she worked at. A young woman who has been railroaded into a murder charge by the detective the state chose not to even present to you today. But members of the jury, in this country, there's something called the presumption of innocence. And what that means is that when Miss Bowman walked through those doors, she was presumed innocent of those 3 crimes the state told you about. As she had to sit there and listen to them call her the defendant, waiting in the shadows again and again, she remained presumed innocent. And we're confident at the end of today's trial, you will find Miss Bowman not guilty, because the state has failed to meet their burden of proof. So what is that burden, members of the jury? It's the state's job to prove to you beyond a reasonable doubt that Miss Bowman is guilty. Now that means that if your reason and your common sense lead you to ask any questions about their story, if there's another single reasonable other explanation for what happened at Rockterworld, that means the law demands you can't find Miss Bowman guilty. Remember, it doesn't take 20 reasonable questions, or 10, or 5. All it takes is 1. And we're going to talk about the 3 most important questions the state has failed to answer. Question number 1, where's the money? Miss Bowman was charged with 3 financial crimes. People commit financial crimes in order to get money, and when they have that money, either they'll spend it or they'll save it. So where's the evidence that Miss Bowman benefited in any way from Cameron Poole's robbery? Do we have evidence that she went out and got a new house, a new car, new clothes? If she was keeping any of the money, where was she keeping it? In a bank account? Did we hear about her bank account at all? Did we hear about a financial investigation at all? Was the financial investigator called to the stand at all? On top of that, members of the jury, the state told you at the start of their closing argument that Cameron Poole was seen running away with a bag full of money. If you remember the direct examination of J.C. Longstreet, what Mr. Longstreet said is that on average, over $20,000 a day, that's what the ticket booth brought in during the month of August at Rockterworld. That's a lot of money to stuff into some kind of sack, members of the jury. You can't just put that in your pockets and run. But we heard from the single eyewitness the state decided to call, the single person who witnessed Cameron Poole's escape, that she didn't see him carrying any kind of money. She didn't see a sack. She didn't even see a knife. Is that proof beyond a reasonable doubt? If you're wondering where Cameron Poole allegedly put all of these thousands of dollars, if you're wondering what happened to that knife, if you're wondering where the money is, that is reasonable doubt. That brings us to our second question. What happened during that escape? The state's single eyewitness, Tyler Hartman, told us that there was panicked yelling, chaos, and confusion, that she couldn't tell exactly where my client was. At one point, the lights went out. She couldn't see anything. She couldn't even tell if Cameron Poole said anything to anyone because the screams, they were so loud. Members of the jury, this traumatic event happened over a year ago. You think she's going to remember the exact timeline, step by step by step? Human memory, it's unreliable at best. So do we have any evidence, any surveillance footage of what was going on there? Do we actually see a picture of my client behind the controls? Or did my client make the simple mistake that others had made before? Jack Hunter, Billy Isaacs, 2 employees back at the other amusement park, of in all that chaos and that panic and that bang sound, accidentally hitting that lever. If you think that's a reasonable possibility, members of the jury, Ms. Bowman can't be found guilty. And that leads us to question number 3. Where are the police? We know that Ms. Bowman was arrested in this case because Mr. Longstreet's old friend was at the park looking into some financial discrepancies and just so happened to hear a scream. Now, the police officer and Mr. Longstreet, they didn't see what happened in the ticket booth, and the state chose not to call the accountant who was actually allegedly robbed. But we know the police officer went on to only ask questions about Miss Bowman. Is this because his old friend, Officer Winston Thomas, was the one who was hurt? He actually cuts off the conversation with Jack Hunter when Jack Hunter says the alleged robber in this case was having meetings with park management. He threatens the security guard, Lou Eccles, with arrest when the security guard wants to talk about Cameron Poole, the man who was seen escaping. Members of the jury, does that sound like a fair investigation to you? Is that an unbiased investigation? Why did the state refuse to call the police officer in this case to the stand? If you would want to hear what that police officer had to say, that's reasonable doubt. Because the state has failed to give you this evidence, because they failed to answer the questions and they failed to meet their burden, equal justice under the law demands that you find Miss Bowman not guilty. It might be difficult to look the prosecutors in the eye and say that in this case, they just got it wrong, that they're following in the footsteps of a biased investigation and a rushed investigation, that they have none of that financial or forensic or scientific evidence. But members of the jury, we don't come into court to do what's easy. We come here to do what's right. Too much is missing from their story. Find Miss Bowman not guilty. Thank you.
Thank you, Mr. Lampert.
was here in the action from scoring, but I think we've still rebuttal to come. Right?
A little confusing in the courtroom. I thought there would be a rebuttal coming up. I don't know if Judge Farrar forgot about that, if they're not choosing to use it. Okay, well, we've got a moment. Two excellent closing arguments. That's the Ian Lampert we were waiting to see.
Yeah.
Absolutely. The line of the round, perhaps the line of the weekend. Defendants make plans. People make mistakes.
There was a lot of folks on Twitter saying they were liking the personal approach to personifying the defendant in this case.
Princeton's closer also did an excellent job. I've waited. I've sat through the entire trial, and I literally heard nothing about the knife. I heard nothing about the bracelets. Princeton, people on Twitter wondering, what is Princeton doing? They went with a very, very minimal case theory. There was no discussion of the knife. There was no discussion of the robbery or the bracelets. An interesting, again, risky move by Princeton. They obviously had a plan of attack. They had a strategy, and they worked it. But it's close. This is a tough one to call. I think it's going to come down to, did the judges like UCLA's characters? Or did they think they were a bit too much? I think UCLA's witnesses were a little bit stronger on the whole, but in the same regard, UCLA's attorneys, in the same regard, Princeton's attorneys really kind of, picked their moments, and I think some of the judges might appreciate that, but this one's too close to call. It's tough. It was a great round, showcasing everything that AMTA has to offer and the two best teams in the country. The general consensus on Twitter seems to be that UCLA is in the lead, but that Princeton team, they haven't lost a battle this weekend.
I'd be curious to see. Let's hear your feedback on Twitter and send us your thoughts right now. Now that we're at the closing, and we'll announce some of them in the break before we have the deliberations finished. Curious about the strategy to not take the break after the close of the defense's case here. Do you think that Ms. Kirchner was caught off guard a bit? Was she well prepared for a close? Do we have enough of the analysis of the defense case in the closing argument?
Her demeanor suggested that she was ready for it.
Yep.
And she certainly didn't skip a beat. She did an excellent job. Let's be clear. This was a power move by Ian Lampert. For those of you watching at home, he doesn't need a break because he gets 10 minutes while she's talking. She's the one that doesn't get a break, not him. And so it's a move I've seen before. Some people cry foul. I bet the judges probably crying a little bit foul because they probably wanted a little drink, a little bathroom break.
Sure.
But they've been sitting in there for a very long time. But I don't know that it necessarily paid off for Ian Lampert. It was certainly, there's not much to say about it. It is what it is. He threw down the gauntlet. She could have easily said, no, Judge, we want a break. But, she threw it right back in his face and said, no, I'm ready to go. I'm ready. And she was ready. And there she is still at the ready, still standing. I'm not sure if she has time for rebuttal left. The timekeeper, Mr. Warahe, okay, I'm being told by our crew that she has 30 seconds for rebuttal. That's not a lot of time. I don't know what she can possibly squeeze out of that 30 seconds. It appears as though the judges may have already scored. She looks a little flustered. If I were her, I probably would have brought this to the judges' attention. So we'll see what happens from there. I see the timekeeper is holding up 30 seconds. So we may have 30 more seconds of mock trial momentarily. But all in all, a great round. A lot of character witnesses. Not a lot of... it's hard to say. There just wasn't a lot of meat to this bone. There was not a lot from the state side of evidence. There wasn't a lot of proof they put on. There weren't a lot of exhibits. There were not a lot of objections. This was a very minimal final round. And I think what it'll be most remembered for are the character witnesses that were out in mass and the strong closing arguments by both sides, both Lampert and Kitchener.
They were excellent. Maybe ready to move on here?
Rebuttal, Your Honor?
And there it is.
I'm sorry. I thought I had read in the rules that there was only state and defense and no rebuttal. I'm sorry.
Just a brief rebuttal, Your Honor.
Okay. Go right ahead.
Before I begin, can I inquire into how much time I have remaining? 35 seconds. Thank you.
Hurry up, my ride is arriving.
Now, Mr. Lampert just got up here and tried to tell you that there is something missing from our story. But ladies and gentlemen, there is someone missing from his. Now, he tried to suggest that just anyone can make a mistake on the Tunnel of Terror. But consider the other events surrounding the crime. Consider that Miss Bowman asked to take over the Tunnel of Terror 3 times, having never insisted on doing that before. Consider that she knew exactly what the lever did, that she'd used it before and broken park rules. Consider that the last thing she said to Mr. Isaacs was about blackout mode. Find her guilty.
Thank you, Ms. Kitchener.
What'd you think of the final 30 seconds?
I think that the judges probably already scored their ballots. And maybe a strategic error on Ms. Kitchener's part not to bring that up sooner. I don't think that they would have been moved or swayed too much by the 30-second rebuttal. You see there in the picture tabulation director Jonathan Woodward collecting the judges' ballots. Those will now be taken to a secure room outside of the courtroom here next to us, where they will be tabulated by 3 of our 4 remaining AMTA representatives here this weekend, both Mr. Woodward, Mr. Nelmark, and Mr. Warahay. We're giving away a little bit here. If you have really good eyesight, you might be able to read that judge's ballots. But they will bring them out here. They will tabulate them, and they will determine a winner. And while that's going on, the judges will give some commentary in the round. You're going to stick with us. If you're listening at home, you're going to stay with us because we don't have the judges mic'd up. And we're going to kind of talk a little bit more about how the round went. And there's
round of applause in the courtroom.
Round of applause.
Well deserved.
Well deserved. Duly earned.
Absolutely.
And then and we see the AMTA representatives leaving the room with the ballots. This is the big moment. This is exciting. Folks are eagerly. Anything the judges say right now is really going on deaf ears. The season is over. The case will never be argued again.
You can see the pressure escaping from the room.
Absolutely.
Like a balloon right there.
Like a balloon deflating.
Absolutely.
They just want to know who won the 2014 national.
Who's got to pay for the shipping to take the trophy home?
It's
right?
got to be. It's got to be backbreaking. It's got to be expensive.
Let me go back to a question I asked you very early on. We didn't hear a tremendous amount of information about the decedent in this case, selfishly, also named Thomas, I might add.
Correct.
Do we think the addition of the felony murder aspect of the case, did that play out in as full of effect as might have been intended when it was added to the case?
Not at all. And, I was talking about this with some folks today. It's difficult because you have sort of a faceless person who passed away. In years past, we had cases where children were killed, or young people or loved ones, and you had, it's tough to have a lot of sympathy for the decedent when the decedent's, for instance, wife or child or mother or father aren't taking the stand. The first witness cried a little bit because she saw the injury take place, but not a whole lot of humanizing of Officer Winston Thomas. The real loser here this year, Officer Winston Thomas.
So on Ian's close, a very impassioned, personal, it was a wonderful close, so I don't want to sound too nitpicky here. But I'm curious about a tactic that he utilized to essentially discuss all of the witnesses that were not brought to the stand by the prosecution. Obviously a limitation a little bit of the structure of the exercise we're doing here today. Is it a cheap tactic? Is it fair play? What was your read on that?
It depends on who you ask.
Yeah.
I've heard it both ways. I've heard that's a cheap tactic. I've heard it's fair game. I'm not going to comment one way or the other. I'm sure I've done it. I'm sure my teams have done it.
Yep.
But you know what? In the situation that Ian Lampert was in, somebody posted on Twitter that the Princeton's theory was essentially, trial by ambush. They cut all the meat out, so you've got nothing to cross on. Well, Ian Lampert took that and, swung it back and said, here's all the stuff they could have brought and showed you. They didn't. So it was almost sort of a reaction to their case theory when he did that. Fair or foul, it's allowed by the rules. So, it is what it is.
I have to ask you the following question. I hate doing it, but I think I'm ethically obligated to, as my role as your co-broadcaster here. Do you want to give a prediction?
It's tough. Again, I can't see into the judges' minds. If the judges liked all of the character witnesses for UCLA, I think UCLA carries the day. If they like the more minimalist approach of Princeton, I think Princeton carries the day. To be perfectly honest with you, I think that going into those closing arguments, this was maybe a tie.
Yeah.
It was maybe a tie. I really was paying attention to those closing arguments to see who carried the day. And Miss Kitchener did an excellent job, thrown up there to the wolves with no break. But, you know, at the end of the day, Ian Lampert's closing was fantastic.
It was spectacular.
It's everything we had kind of hoped to see in this round. And at the end of the day, if UCLA does win, I wouldn't be surprised if they win some ballots on the strength of his closing argument.
A lot of smiles in the court right now, including from our defendant, which is nice to see. She has broken character at last. She did a tremendous job in a obviously an unspoken role, but really did a tremendous job.
A difficult role. She was handled by almost every person at that table. A lot of hands on her, a lot of grabby on her shoulders, and she dealt with that well. She looked solemn throughout, and she did do a good job. And so
12 folks should be very, very proud of themselves right now. That's for sure.
Absolutely.
Let's take a quick look on Twitter and see if we got a lot of folks here throwing some names out there of who they think might have won, if they agree with you or not. Princeton had the case in chief, but UCLA takes the closings. That is Emily's thought here.
I agree.
Emma says a lot of character witnesses, not a lot of substance. Substance is the word you're looking for.
I also
we appreciate
agree.
the assist. Yeah. Erin thinks UCLA has this. Then I guess that's about it at the moment. Let's see, more coming in. A lot of folks ask for predictions here. A lot of folks, I think, scared to go out on a limb, which is a surprise from the Twitterverse. I'm not going to lie.
There were some fairly strong opinions there.
Twitter's blown up too.
Yeah. While we're at it, let's take a moment after the round is over. We're going to try, if we have some time left on the air, I'm going to try to get the coaches of both teams over here to ask them a few questions after the results are announced. But while we have a moment, we would be remiss if we didn't recognize the folks who put all this together. And that starts at the top with Margarita Koblatz, the head coach, the advisor here at the University of Central Florida, who put on a wonderful national championship tournament, one that is going to be very difficult to live up to next year. And everyone at the University of Central Florida, they were a big sponsor. Stetson Law School was a sponsor, and we have a screen for them. Kaplan, whom I'm understanding employs you.
Yes, that is correct indeed.
Was a sponsor. The folks here at WKMG who have spent the better part of the day with us. I am new to this, and they've been very generous and gracious with us, shepherding us through this process. It has been a delight to be here. And most importantly, all of you at home, when this happened, we were hoping that people were watching and that people were being involved. And the feedback on Twitter and on Facebook has been excellent. We've had a great interaction with you folks, and I'm told that the ballots are heading into the room. The ballots are heading back into the room. I don't know if that means they've been tabulated or if a score is missing, as is often the case. But we may be able to finish here shortly.
This is exciting.
It is. This is what we've...
UCLA has it on the close votes here at the end here on the Twitter.
Okay.
The Twitter. Look at that. The Twitter. I'm going to get blasted for that, I'm sure. But a couple votes for Princeton, but UCLA seems to have the edge here on the Twitter votes.
Well, we'll see what happens. Like I said, this is what everyone's been waiting for. At this point, the students are just wanting the judges not to talk. Right. They see the amped reps come back in with the ballots. They want to know who won. There's probably a lot of nerves in there.
Have you found in the past, while we wait to see when they're ready to read, is it often the difference between the attorneys or the witnesses that skews the scorecards? Tough to say.
Witnesses.
Witnesses, really.
Because there can be such a huge disparity in witnesses. there are times when, you know, if you have no character, no costumes, no accents, nothing, versus a team who has all that, doesn't matter how good the attorneys are. You can all be great attorneys, but the witnesses will often carry the day. And the difference between a very strong program like UCLA and teams that are not as strong is that they don't develop witnesses as much. Right. And that's not saying taking anything away from Princeton. Certainly. Princeton developed some very strong witnesses as well. In reality, about 5 of the 6 witnesses were character witnesses. So
that's great.
At any moment now, I don't want to speak over the announcement of the national championship winner, so we're going to keep an eye on the live feed here. I'm hoping that Mr. Warahay and Mr. Woodward will make sure that we're done before we cut back into them.
I think we still have a little critique going on by some of the presiding judges today.
Okay. And someone is bringing us a handheld mic so that we can perhaps do some interviewing after this if there's time, if they don't cut us off.
Nice round of applause for all the participants in the courtroom.
And one of the things I most liked about the witnesses is they didn't really get tripped up because they knew the facts. And I know how hard it is to have somebody give you a story that you didn't actually live and have you memorize it so well that you can go through direct and cross like if it really happened to you. Granted, I'm sure you've had to tell this same case 50,000 times. But that being said, you know, you all had a command of the facts of the case, and you were able to answer the questions no matter who was posing them to you, your lawyer or the opposite side. So job well done to the witnesses. Anything else, anybody? Yes?
I just want to let you all know, I started out as a debater in high school. Okay?
I'm sorry, as a what?
A debater.
A debater.
I wound up with a scholarship to debate. All that I can tell you is that when you read my comments, some of them may be very tough, but they are in line with what I saw as a debater.
Okay, we're getting a few extraneous comments here at the end from the last judge there, but we are moments away from announcing the winner. Jay, you're new to mock trial, so to speak.
I am.
As a complete outside observer, you're an attorney.
I
So
am.
you're qualified.
I've done a little of this in my day.
Who'd you think won the round?
You know what? I'm going for Princeton here.
Okay.
I was intrigued by particularly the approach of some of the cross examinations. I'm going to the character witness deal. You know, we'll see how that all plays out. It's just a matter of personal preference, I think, at this point for me. I have not been keeping score, a running scorecard, the way that you have throughout the course of the match. Unfortunately,
I've not necessarily been keeping score, but if I did, you know, I would probably stick with my original prediction.
Yep.
But again, it comes down to those character witnesses.
It is just, I mean, to be so new to this and have the pleasure of getting to sit in on the final round of the national championship.
And this is
quite the inauguration.
Yeah, and this is a really amazing experience for everyone at home because for years and years and years we videotaped these and we put them on DVD.
Yep.
And, you know, it's one thing to call and order a copy, but to see it live online is great. And here they come.
Here we go.
Here they come.
So before we announce the results of the round, we're going to recognize for the webcast. We're going to recognize all the members of both the teams that participated in the trial. We will start with the members of the team that did not actually participate in the trial. So for our prosecution team, we have Paul Riley. Taylor Hinojosa. And Peter Angelica. Those three are individuals that competed this weekend, just not in this trial. For UCLA, for our defense team, we have Elise Soderberg. Connor Wynn. And Tiffany Fahn. Our witnesses for the state today, J.C. Longstreet was played by Shu Yang Lee. Tyler Hartman was played by Charlotte Williams. And Billy Isaacs was played by Brandon Holt. Jack Hunter was played by Tim Hoyenga. Francis Conroy was played by Callie Davidson. And Lou Eccles was played by Philip Rucci. Our attorneys for the state, our opener was Mr. Ray Chow. Our middle attorney was Anna Niermond. And the closing attorney was Caroline Kitchener. For the defense, our opener was Kyle Gomez de Camp. Middle attorney was Carolyn Paris-Bear. And the closing attorney was Ian Gabriel Lampert. All of the names that I just announced, by virtue of competing and being on a team that advanced to the national championship round, you were all All-American attorneys and witnesses. Congratulations. And now with that, I will turn it over to our tabulation director for the results.
By the way, could we know the schools? We didn't know. UCLA apparently is one.
I was just going to mention that, since apparently we haven't gotten to that. Representing the people of the state of Midlands today, Princeton University. And representing the defendant, the University of California, Los Angeles, UCLA. There have been 29 champions in the history of the American Mock Trial Association, and it is my great honor and privilege to crown AMTA's 30th national champion. On behalf of the American Mock Trial Association, and by a 3-2 decision of your scoring panel today, it is my great honor to present the Richard Calkins Award to AMTA's 30th national champion, the UCLA Bruins.
Well, you know, as we expected, a very close round.
As you predicted. Congratulations to you.
I've been doing this for a long
You
time.
have.
This is my 16th year of involvement with the American Mock Trial Association, and I knew two things. I knew it was going to be very close, and I'd love to see the scores, and I knew that. I think that at the end of the day, Ian Lampert's closing sealed the deal
It was
for at
spectacular.
least a few of these judges. And maybe when they come out here, we'll get to know the differentials in the scores, how close they were. I don't know how much AMTA wants to reveal of that, which judges scored what. We're going to momentarily here, I'm hoping that the head coach of the UCLA Bruins, Gonzalo Freitas, will come out and speak with us. Obviously, he's in there and very elated at the moment, having just won his 4th national championship, which I believe ties him with Rhodes for the second most.
And Ian gets his bookend, as you talked about earlier.
Ian does get his bookend.
And well-deserved.
Well-deserved. A great story. By all accounts, a great kid. And there we see in the background Mr. Freitas congratulating his students. He's speaking with the coach of Princeton, Robert Marshall, there in the green shirt. I hope to be able to speak with both of them here shortly just to get their feedback on what they saw in the round. Judge Farrar. And there in the middle of the screen is Dr. Margarita Koblatz, the head at UCF in the tournament.
And I believe he's autographing his nameplate that he's going to present to the winning team, correct?
Absolutely. One of the things, the first thing I saw when I came in the tab room this weekend was that his plate was there, and he said, I'm going to sign that, and I'm going to hand it off to the winners. So that not only will UCLA go back to Southern California with the Calkins Trophy, but they will also go back with a signed placard from Judge Farrar.
Wonderful. A lot of folks here on the Twitter congratulating folks, of course. Wouldn't be surprised to see Princeton in a final round sometime soon. Again, I'm sure, if not at the 31st, at your tournament for sure. A couple folks, Brian says, well said, 3-2 decision, the way it should be to win a national championship. Congrats to UCLA. Good job to both teams. A very interesting round and well done to UCLA, says Amber Verdi. Tears, laughter, hugs for everyone on the UCLA team. Lots of celebration and elation, I think, all around by all 12 contestants, not just the 6 that emerged ultimately victorious today. Lots of love being poured out on Twitter right now for our folks at UCLA.
Absolutely, and again, well deserved. I can't overestimate the amount of time that these students put into this event, year in and year out. The 9 months of work, long nights, weekends away from home. It is for everyone who competes. It's very rewarding. It's the end of another season. A new one will be right around the corner. You see Gonzalo there embracing his all-star closer, Ian Lampert, as well as his young witness. Again, we hope to have him out here momentarily. Actually, I see that Mr. Mike Kelly, one of the assistant coaches with UCLA, is perhaps on his way out. Maybe we can speak with him first. We haven't heard his name, but he is one of the coaches for the University of California, Los Angeles. Here comes Gonzalo Freitas.
Excellent. I'm going to take a step out for a quick second. I'm going to give you the opportunity to interview a couple folks here. Want to bring it on first?
Yeah.
Yeah, let's bring it on first. Ian, would you mind coming over, buddy? Yeah. Come grab a seat in this chair right here. All right. I'm going to take a step away for a second. Just put on this headphone if you don't mind. Okay. First of all, congratulations.
We have the star of the round in one moment. We're on camera. I'm here with the closer from the 2014 National Championship Tournament, UCLA, Ian Lampert. Ian, this is 2 for you.
This is.
How does this compare to the first one?
My first year winning nationals, I barely knew what mock trial was. I'd only competed for half a semester at that point, and I was brought up by a bunch of phenomenal competitors, including one of our coaches, Brandon Hughes, who closed that final round on the defense. I didn't realize the gravity of this activity and how much everybody puts into it. I learned a lot about that in the last couple of years, so the fact that I had this opportunity is unbelievable.
Well, I'm going to ask you some of the questions that people want to hear. First of all, what's more nervous for you, sitting here right now or doing that?
It's definitely sitting here.
Good. I anticipated that. So a couple of things happened around. I want to get your reaction. Number one, first and foremost, Princeton's case theory. They didn't talk about the knife. They didn't talk about the bracelets. How did you all respond to that?
At first, we were very nervous about that. On my direct examination of Jack Hunter, the NASCAR reporter, there's a whole series of questions we ask about the bracelets, and we try to cast doubt on that theory. We knew we couldn't do that in this round, so when I questioned him about bumping into the lever with his gut, he made that up. We made that up on the fly. We just had to react in this case, as I guess a defense should do.
Okay, and the second, Twitter's going crazy. You guys were in the round. You didn't know this. There are a shocking amount of people watching this today. You'd be surprised. And Twitter was blowing up all day. The big power play move. You said we don't need a break between closing arguments. Was that something you talked about ahead of time? Was that something you had planned? And do you think that it worked out?
It's something that we just kind of do. On the prosecution, when we rest our case in chief, we say, we're ready to go if the defense is. And it's rare that the defense is ready to go. In this case, the prosecution closer, she's just so good. I don't think it fazed her at all. I don't think it was really an advantage here. She was just as good. I mean, she could have been even more phenomenal with the break, but she was just great. So I don't think it made too much of a difference in this case.
Yeah, I agree. I don't think she missed a beat. Other thoughts? Is this it? Is this the end of the road for you? Are you graduating?
This is it. This was my last round of mock trial ever.
Well, you know, like John Elway winning a Super Bowl and walking off into the sunset, you've won the national championship tournament. This is, you know, you want to be playing in that very last round, and you did that. So congratulations. Congratulations to your whole team, to your coaching staff I see out here. They're going to miss you. What are the plans for the future, Ian?
I want to teach. I was recently hired by a charter back in Van Nuys, California, where I'm from, and I get to teach speech and debate, which is my background. Never did high school mock trial, just speech and debate.
You're not bad at it. You're not bad. You've got a thing. You've got a thing for it.
Yeah, just speech and U.S. history. So that's what's in the future.
All right. Well, Ian, it was great. It was great watching you. Excellent round. Congratulations on your national championship tournament. We're going to bring in your opposing counsel here and ask her a few questions as well.
Sure thing.
Thanks, Ian. Will do. We have approaching now the live feed. We were just speaking with Mr. Lampert. Now, we've got different spellings of your name on the roster and on the live feed. What is your last name?
Kitchen with an ear on the end.
Kitchener.
Yes.
Kitchener. All right, Miss Kitchener, have a seat.
Nice to meet you.
Joshua Leckrone, nice to meet you.
Nice to meet you.
Well, wow. When you arrived in Orlando on Thursday or Friday, did you have any idea that you would be participating, you'd be closing against Ian Lampert in the national championship round?
No. Princeton has had. Oh, I'm on camera.
Yeah, we're live on camera. We're on the internet.
Okay. Wow. Well, hello everyone. Princeton has had kind of a. We call it our underdog story, because my team that I was on, we didn't even make it out of regionals. The other team from our school qualified, and most of the competitors on this team did not qualify from regionals.
And my understanding is the person in charge of finding sites, you all almost didn't even compete at regionals this year. Is that correct? There were some weather issues. You guys couldn't get to regional?
Yeah, we did. There was a snowstorm, so we couldn't get to our original regional. They were very gracious and allowed us to go to Delaware instead.
Excellent.
But yes, it really didn't look like, we weren't on any of the rankings on perjuries. I don't know if you know about perjuries.
I don't. I know about it. I don't care about it. But
yes, according to the people on perjuries, we didn't have a shot. So.
Well, I can't remember a time, Carolyn, when a team didn't lose a single ballot in a 3-judge panel tournament. I mean, you all didn't lose a single ballot. You tied a ballot.
Yeah.
Amazing. Yeah. And, obviously you came up a little bit short in this round. It was very close to 3-2, But that accomplishment in itself is amazing. You all walk out of here with the runner-up trophy, and you walk out of here with both an All-American Attorney Award and an All-American Witness Award.
Yes.
I mean, you're a big name in mock trial now.
Wow.
What year are you? What year are you?
I'm a senior.
You're a senior. Is this it for you?
Is this it for me? I mean, am I going to law school?
What are the plans from here?
Well, I'm planning on, I'm going to be kind of a Jackie Hunter journalist for the next probably year or two, and then I'm going to focus on my writing, and then I'm going to try and go to law school.
Interesting. So neither you nor Mr. Lampert are headed straight to law school,
No.
and there's nothing wrong with that, obviously. But both of you finishing in the top round in the country this year, you can't complain about that.
No, it's very exciting.
You were wonderful in there. When you get home tonight, you'll have to look on Twitter. You're sort of a thing on Twitter right now.
Wow.
For good or for better or for worse, you're sort of a thing on Twitter right now. Let me ask you 2 questions that I just asked Ian. Number 1, were you thrown off by the fact that he said let's skip the break between closings? Because that meant you had to immediately start giving your closing. Did that throw you off?
Well, I definitely wasn't expecting it. We always have a 5 to 10 minute break between the end of the defense case in chief and the closings. But I don't know. I've done that closing so many times, and I feel very comfortable with it. So I was ready.
Okay. The other thing was there were a lot of people on Twitter, myself included, were very surprised by the very minimalist case theory you all had on the prosecution side. You didn't talk about the knife. You didn't talk about the bracelet. What was the thought there? What was the strategy there to kind of take away what the defense could really cross-examine on?
Well, we kind of looked at our case, and we looked at the case, and we saw a lot of very distracting elements to it. It's just so much when you're talking about a wristband scheme, you're talking about a robbery, you're talking about a murder. There's just so much, and in In a case in chief, there's only so much that you can do. In a closing, there's only so much that you can do. So we wanted to take away a lot of the things that we saw as distractions to the main points that we wanted to make. And that's what we did in our prosecution case in chief for nationals.
My sources tell me, I was not there, I was here with the final round judges, but my sources tell me that you all won the coin flip.
Yes.
And you chose to go prosecution. You chose that. Well, what was the thought behind that? Was there a specific strategy?
Well, we'd had some scouts and we'd seen UCLA's D, so we thought that that might give us a little bit of an edge.
You thought you had a better opportunity against their defense than their
well,
state.
we hadn't seen their other side.
I gotcha. Fair. Well, the world is watching. Anything else you want to say? I'm not going to keep you here. Your teammates are out here. Your coaches are out here.
Thank you so much for watching and being interested in mock trial. This has been a lot of fun for me.
Thank you very much for competing and for a wonderful final round. Your closing argument is incredible.
Thank you so much.
Thank you. We now have with us the coach of Princeton University, Robert Marshall. Mr. Marshall, excellent to meet you.
Thank you.
How proud of you of your kids?
Oh, incredibly. I mean, I just graduated last year, so I was on a team with a lot of these guys for the last 4 years, before this year, obviously, and it's just amazing to see how well that they've done
Now,
this year.
are you the extent of their coaching?
Yes, we've actually historically been an uncoached program, so we took on a coach early this semester who was just a trial attorney who wasn't particularly good, and were in really dire straits at the beginning of the season, and everybody's trying to distract me now, but they took me on in January, so I've been really enjoying it since then.
Excellent. Well, I'll tell you what I just told Caroline, which is an amazing accomplishment by your team in that you all didn't lose a single ballot in a 12-ballot tournament. That's unheard of, especially at this level. And I know not winning the final round isn't the ending that you wanted, but what an amazing, incredible accomplishment you all have had. Has that really sank in how well you all did this weekend?
So I've sort of always described the philosophy that a lot of what happens in mock trial comes down to luck. So while I definitely think that the team is excellent and we put an enormous amount of work into it, and there's some skill in the group of them, there's a lot of luck involved in picking up as many ballots as we did. That being said, obviously ecstatic, very, very proud of them, and I absolutely knew they had it in them to do this kind of thing.
Yeah. Well, just so you know, we knew it was going to be close. It was close. The folks on Twitter, the Twitter was going crazy. We had a ton of viewers here. You might not know this, but there were a lot of people watching, a lot of people talking about it. There were a lot of people that thought you won the round. There were votes both ways. It was extremely close. I'd be interested to see the differentials. Have you seen the differentials on the ballots?
I've seen the differentials. There are a few of them that are narrow. We picked up one +1, I think, and then the other one was also a narrow margin. The ones that we lost were narrow as well, with one exception, which was double digits. So.
Okay. Well, listen, once again, congratulations. Good luck next year. You guys are a big name now. As I said in the beginning, 67th ranked BBR. According to AMTA's rubric, you're the 67th best team in the country, but here you are, one ballot away from winning the national championship tournament, and we expect great things from Princeton in the future. So thanks for coming by, Robert.
Thank you.
Good to meet you.
Good to meet you, too.
The parade of characters continues. I'm now being joined by the one and only Jonathan Woodward, tabulation director, the man who just announced that UCLA had in fact won its 4th national championship tournament. What was the excitement level in that room?
It was exactly what you should expect from a national championship tournament. What I expected was what actually happened when I announced that it was a 3-2 result is that everyone got real nervous. I think anytime you let folks know that it's something like a 4-1 or a 5-0 decision, people maybe have a better idea of what actually happened. Here, when it was a 3-2 decision, I think folks started to wonder whether the round went maybe the way that they saw the round going. So, but great for UCLA, great group of folks, and Princeton put on a great trial too.
Absolutely, absolutely.
It was really a great showing from both of them and a testament to the quality of all of our competitors.
Absolutely. And is it safe to say, I was just asking Princeton's coach what the differentials were, is it safe to say that a few points could have swung the national championship to New Jersey?
Absolutely, absolutely. A couple of the one of the ballots was +2 for UCLA. Another one of the ballots was +4 for UCLA. On the flip side, one of the ballots was only +1 for Princeton. So I think anytime you get to this level of the competition, you see that the margin of error is very, very small, and even very slight differences can result in a swing of a ballot.
All right. Now, as an outside observer, I'm going to ask you one more question. Jay and I were out here talking, and Jay says to me, would it be odd or typical for a student to ask to have the court reporter read something back? And I said, I don't know. It's never happened.
Sure.
We've never had a court reporter. And I said, how amazing would it be if somebody did that? And this gentleman standing right behind the court reporter,
Mr. DeCamp.
Mr. DeCamp,
Yep, first one to try it out.
It did not go great.
No.
Judge Farrar had better luck with it.
That's true.
It felt from outside the room watching, it was a little awkward. Was it unusual in there?
It was, only because it seemed like our friends from Phipps Reporting, who did a great job,
Sure.
Maybe weren't prepared for that, weren't expecting to actually be used the way that a real-life court reporter might be expected to be used. But I think the important thing was that Mr. DeCamp handled it very, very well. I think most of the awkwardness was not so much on his part. He rebounded very quickly, did what he needed to do, and I don't think that was a negative factor in the scores that the judges gave him. They saw that he was doing what an actual trial attorney would do, and scored him accordingly.
Okay. I'm told that we have a few more people that we need to speak with.
Folks don't really want to hear from me anyway. I mean, let's just be honest.
They're all waiting for Will Warahay.
That's who everyone wants to hear from in AMTA. I know it.
All right, we're going to bring on Jonathan. Thank you.
Thanks, Josh.
Excellent job.
Great job with you today also. Everyone's talking about the great job you've done.
I appreciate it. We're going to bring on really the star of my commentary, Mr. Kyle DeCamp. No one really, he can't hear me until he puts his microphone on. Mr. DeCamp.
Hi.
Joshua Leckrone.
Good to meet you, Joshua.
You're sort of probably the most talked about person in the round today for a number of reasons. First of all, I commented very perhaps unfairly on your shirt and tie. I didn't think it matched, but now that I see it up close, it's a little better.
The gray, the red, and the white?
I still don't love it, but it's a little bit better. But an incredible opening statement. Excellent work out there. What everyone wants to know on Twitter is, why ask the court reporter to read it back?
I thought it would be really effective to have Lou Eccles be able to hear what Tyler Hartman said and be able to completely corroborate it. It's like, yeah, that's exactly what I told Miss Bowman to let everyone know. So that way it would seem less unnatural for Miss Hartman to have heard that. And I thought if I could get the actual quote, it would be the most effective.
Right. As you're standing there and the seconds start ticking away, doesn't it feel like it's taking minutes and hours? It felt out here like it was a very long pause. Kind of like, why aren't we just kind of moving along?
Right.
Did it feel like that in the courtroom? Were you starting to get nervous?
A little bit. I always knew that I had the fallback if it didn't work out. But I definitely felt a little bit of nerves. It took maybe about a minute out of the time, I think, just standing there. And I felt most bad about the fact that the court reporters didn't know what to do with the situation.
Well, they weren't. It's in real life, you'd go back to the specific date and time, that kind of thing. But yeah, they probably were not anticipating that. It's never really happened in mock trial before. But again, though, congratulations.
Thank you, sir.
What year are you?
I'm a sophomore.
A sophomore, so you've got some time ahead of you.
Plenty of time, yeah.
And by my notes, you won an All-American Attorney Award.
I did, thankfully.
Now, in the ride home, how much will you make fun of Ian Lampert that you won one and he didn't?
I wouldn't do that.
You wouldn't do that?
Ian's been an amazing co-captain and co-counsel all year, and I can't think of anyone who deserves it more than he does.
That's the nicest thing I've ever heard anyone say.
I try.
We have one more person that's going to come up and speak with us. Congratulations on winning the 2014 National Championship
Thank you. Appreciate it.
We have one more interviewee. He doesn't know it yet until he puts on his headphones. We are joined, we're going to try to get the camera on. We are joined by one of the 5 final round judges, Judge Jose Rodriguez. Judge Rodriguez, let me ask you this first. Have you ever judged an American Mock Trial Association round before?
No, this is my first time.
But it will not be my last time.
And that's what we love to hear at AMTA. What are your just initial thoughts having seen this, knowing that these are college students? These are barely out of high school, some of them.
Phenomenal. They're ready. They're not only ready for law school, but when they come out, I mean, if we did not know that they were college students, you would say they're prepared. They're prepared. It's just a matter of someone signing them up, working for a law firm. They are that good.
Yeah. Now, you're a circuit judge here in Florida. Where do these students, with their delivery, their skills, their objection abilities, their knowledge of the rules of evidence, are these students, I mean, better than some of the attorneys you see on a regular basis in your own courtroom?
Yes, absolutely.
I had to ask that.
You notice how quickly.
Yeah.
Oh, absolutely. I mean, this is a great bunch. This is a phenomenal bunch.
Excellent.
I know I said that before, phenomenal, but I'll say it again. Incredible. I mean, I wish they would come to law school in Florida. I'd like to invite them to come to law school in Florida.
Both of the teams are from very far away from Florida, but they may end up here.
I told them that they could come. If they come to one of the two law schools here in Orlando, they could wind up going over to Cocoa Beach and surfing on the weekends between writing their briefs and studying.
Or working for Judge Jose Rodriguez.
They could wind up absolutely being an extern, no problem.
Judge, let me ask you this. This is a little different from real life. Obviously, what got put on out there was a bit of a legal play. What did you think about all the character witnesses? You don't see that normally. There were so many.
Are you sure?
Well, maybe you do. Maybe I misspeak.
Yeah, let me put it to you this way. We are the home of Disney World, which as a park and as an attraction is full of characters. But I guarantee that any time that you come into court, you could see a character or two of our own, a real life character. Life is funny that way.
Excellent. Judge, anything else you'd like to say? Believe it or not, there's actually a startling amount of people watching and tweeting at us on the Twitter. Anything else? Any final thoughts? I think you're the last person I'm allowed to interview. They're going to cut my mic off here soon. Final thoughts on what you saw today?
Well, I will tell you that based on having been involved in watching the caliber of these students, I am going to be, let me begin by saying that as a UCF graduate and a UCF Knight, undergraduate, I am going to be more involved in preparing these students. I started out in high school. I was a debater, pretty successful in high school, and what I saw the same skills of being able to stand on your feet, cross-examine, do direct examination, and what I really found phenomenal in the team that actually won, that they were able to weave from the beginning, from the opening statement all the way to the closing statement. They were able to weave that one thought, that one theory of the case, that you have to be a real pro as a lawyer to do that and to be so consistent throughout the entire case. That's something that hopefully I can assist with the undergraduates at our own hometown school.
Great.
Charge on Knights.
Well, thank you, Judge Rodriguez. It's been a pleasure. We're going to bring in, thank you for judging.
My pleasure. Completely. I mean it.
Hopefully we'll have you judging again in the future.
Absolutely.
All right, thanks.
Count on it.
Thanks, Judge. We're going to bring Jay back in here and wrap things up momentarily. We see on the Twitter feed the Jackie Hunter is carrying the Calkins Trophy throughout the courtroom.
Josh, my man, you got a career in broadcasting, my friend.
I'm hoping so. I'm going to quit my day
job. First time out of the
job.
box. You kidding me? You had fun too, didn't you?
We had a lot of fun.
You can tell. This is a blast, isn't it? It is a good time.
This has been a tremendous experience, and I just hope that for all the kids at home, the parents, the grandparents, the sisters and brothers, that don't get out to see their loved ones and friends do mock trial on a regular basis, that they were able to watch this, that they enjoyed it. It was an excellent round, that our commentary added and didn't necessarily detract from it, and that they learned about what mock trial is, that their loved ones and friends put so much time and effort.
It was a tremendous experience. Of course, the road ends here now in Orlando, but we are only about 365 days away from your show in Cincinnati. Anything we look forward to?
A lot to look forward to. We're in the planning stage still, but I'm very excited. I can reveal to people that want to know that the opening and closing ceremonies will actually take place in Paul Brown Stadium, the home of the Cincinnati Bengals. And I'm very excited about that. We've got some other things in store. We won't have Disney World, but we'll have some other things up our sleeve, and I'm excited. It's a lot of work, but this is about my 16th year in being involved with Ampton. I can't think of another thing that I've been excited to be a part of other than hosting the 2015 National Championship Tournament at the University of Cincinnati.
Well, I hope before that you guys have the opportunity to relish and enjoy what was a very successful 2014 tournament and toast it right and celebrate it, because it was a tremendous experience to be a part of, and I appreciate you inviting me to join you for the tournament this year.
You as well, Jay,
great.
and I'm told we're going to thank our sponsors one more time. Stetson Law, the folks here at the University of Central Florida, Kaplan, and of course, last but certainly not least, the incredible, wonderful job put on by Margarita Koblatz and all of her mockers here at the University of Central Florida. And with that,
I think that's a wrap. We'll be the Masters next year. But until then, thanks guys for tuning in. We certainly appreciate it. Have a wonderful night.